Good morning, everyone, and welcome to today's hearing, at which I am joined, as usual, by my fellow panel members, Ms. Thuria Istefan and Mr. Ali Akbar.
Good morning.
Good morning, everyone.
Today marks another step in the progress of the inquiry because we're going to hear opening statements in relation to Module 3. A number of core participants are going to make oral statements, although a greater number have also provided some written opening statements which will be available to view in due course. Before we hear them, however, I'm going to invite Counsel to the inquiry, Mr. Richard Millett, to make an opening statement of his own. Yes, Mr. Millett.
Chairman, thank you. Good morning, and good morning, members of the panel. Today, we start Module 3 of Phase 2 of the inquiry's investigation. In March 2020, the inquiry set out the structure of Module 3. It is to be divided into 3 distinct but closely related topics. In summary, Topic 1 will consider fire-related complaints. Topic 2 will consider the extent to which the Royal Borough of Kensington and Chelsea Council, RBKC, and the Kensington and Chelsea Tenant Management Organisation, the TMO, complied with their respective obligations under the Regulatory Reform Fire Safety Order 2005, the RRO. And Topic 3 will address active and passive fire safety measures within Grenfell Tower. Although the ambit of Module 3 is broad, there is a single unifying theme. That is, whether and to what extent RBKC and the TMO and others performed the duties they each owed in respect of fire safety. That unifying theme will be investigated from a number of different perspectives, starting in Topic 1 with the evidence of those who lived in the tower. It is, in the inquiry's view, vital that consideration of fire safety matters affecting the building and those who lived there begins with the evidence of those whose health and safety was, or should have been, the primary aim of the fire safety duties of the relevant duty holders. We will examine communications between residents and the TMO, in which the residents drew attention to defects in design, choice of materials, or quality of workmanship, which they said increased the risk of fire, or which the evidence suggests may, in the event, have contributed directly or indirectly to the outbreak or development of the fire. That examination will be conducted through the live evidence of residents and by reading into the record relevant extracts from BSR's statements and consideration of contemporaneous documents. The examination will cast light on the nature of the relationship, in particular between RBKC and the TMO on the one hand, and residents of the tower on the other. In particular, the evidence will focus on whether the TMO's response to residents' concerns regarding fire safety before the 14th of June 2017 was appropriate and effective. After the residents' evidence, the inquiry will then hear from those at the TMO who were responsible for, who were involved in consideration of, complaints concerning fire safety matters, whether operationally, strategically, or otherwise, and also from others such as RBKC councillors and other officers of RBKC who were responsible for scrutinising the TMO's activities and for discharging RBKC's own fire safety related duties. In that respect, the inquiry notes and welcomes the various admissions made by RBKC in its opening statement. In particular, the inquiry notes RBKC's acknowledgement that the number of its officers devoted to monitoring the TMO was insufficient, given the number of residents whose properties were managed by the TMO, and the scale and importance of the task delegated to the TMO. RBKC has also made other concessions and admissions in its written opening statement, for which the inquiry team is grateful. For example, RBKC has recognised that as part of its arrangements for scrutinising the TMO, it never made fire safety the subject of a key performance indicator. It has also accepted that its audit arrangements consistently fail to identify the absence of key performance indicators governing the TMO's completion of fire risk assessments, outstanding significant actions identified in fire risk assessments, or enforcement of deficiency notices served by the London Fire and Emergency Planning Authority. On any view, these are significant deficiencies in RBKC's arrangements for monitoring and scrutinising the effectiveness of the TMO's compliance with its fire safety obligations. The inquiry also notes that the TMO has made no concessions in its opening statement. Whether that remains its position following the conclusion of the evidence will remain to be seen. Whether the concessions by RBKC go far enough will be an important question when the inquiry turns in topic 2 to consider the extent to which those bodies performed their respective obligations imposed under the RRO. Inevitably, this aspect of the inquiry's investigation will be wide-ranging. It will examine the adequacy of the TMO's management of fire safety and the effectiveness of its arrangements for carrying out fire risk assessments. We will also investigate the competence of Mr. Carl Stokes, the TMO's retained fire risk assessor, and the adequacy of his fire risk assessments, but also in particular, the adequacy of his advice regarding the cladding and the TMO's consideration of that advice. We'll also consider and investigate the acts and omissions of those responsible for implementing, supervising, monitoring, and scrutinising the effectiveness of the TMO's fire risk assessment arrangements. The evidence will focus on 3 principal questions. First, whether the TMO maintained an adequate evacuation plan for the tower or identified those residents of the tower who were vulnerable, and if not, why not? Whether it assessed the risks that those individuals would face in the event of a fire or take steps to mitigate those risks. If not, why not? Importantly, whether the TMO ever prepared personal emergency evacuation plans, or PEEPs, for vulnerable residents of the tower. If not, why not? Secondly, we will focus on whether there was a suitable and sufficient fire risk assessment programme for Grenfell Tower, including the effectiveness of the arrangements for ensuring that significant actions identified in fire risk assessments, or FRAs, were implemented efficiently, effectively, and expeditiously. Thirdly, whether the arrangements for maintaining active and passive fire safety systems were effective, with particular attention to the inspection and maintenance of self-closing devices on flat entrance doors in the tower. Factual evidence regarding fire risk assessment will be followed in topic 3 by consideration of the active and passive fire safety measures in the tower, and will do so in the following order: gas, smoke control, repairs and maintenance, fire doors, especially flat entrance doors, and lifts. Experts have been retained to assist the inquiry's investigation of gas, smoke control, and lifts. That expert advice will be adduced after the factual evidence that is relevant to each of those matters that have been heard. So Mr. Hancock's evidence will follow that of the 2 gas witnesses. The evidence of Dr. Lane and Ms. Menzies on smoke control will follow that of the smoke control witnesses, and Mr. Hawkins' evidence on lifts will follow that of the factual witnesses about lifts. Module 3 will conclude with the evidence of Mr. Colin Todd and Dr. Barbara Lane on fire risk assessment. There are some housekeeping matters that I should highlight. First, the inquiry will not sit on the 14th of June this year, which will be the 4th anniversary of the fire. We will not sit on that day out of respect for those who died and to allow those who grieve to remember their loved ones and for all of us to reflect privately on the tragedy. Secondly, the inquiry will not sit on the 2 bank holidays that fall in May. Thirdly, the inquiry secretary has written to core participants setting out the plans for attendance at the inquiry's venue. As matters currently stand, we will restart limited attendance hearings at the inquiry's premises at the start of the witness evidence for Module 3. That will be on Monday, the 19th of April. In order to comply with government restrictions and the risk assessment for the building, which has been carried out by the Government Property Agency, attendance will need to be strictly limited at that stage, in exactly the same way as it was before Christmas. To the panel, counsel to the inquiry, the witnesses and their representatives, and a small inquiry operations and support team. If government restrictions then permit, after the 17th of May, we plan to open the inquiry premises more widely, our first priority being to allow a number of BSRs to attend to watch the proceedings in person. We are giving careful thought to the practicalities of how we can do that, both safely and fairly, and the inquiry secretary will write to core participants further about that in due course. We will have to consider further relaxation of the measures governing attendance at the premises in the light of any ongoing government restrictions and guidance in force over the summer. We will, of course, keep core participants and the wider public informed of our plans. Fourthly, Jonathan Sacula, the inquiry's cladding expert, will give evidence on Thursday, the 29th of April for 1 day. Mr. Sacula's evidence is relevant to Module 1, and so to allow core participants to complete the drafting of their written closing statement for Module 1, the inquiry has decided to call Mr. Sacula as soon as his schedule and the inquiry's timetable allows. Fifthly and finally, the expert evidence of Dr. Lane and Ms. Menzies concerning smoke control will be disclosed as soon as possible. The inquiry will then give directions for the service of written opening statements on the topics of smoke control, and if needed, a half day has been allowed for oral opening statements on that topic. We will keep core participants and the public updated as we go. Mr. Chairman, members of the panel, that concludes my opening statement for Module 3.
Thank you very much, Mr. Millett. Well, at that point, I am in a position to invite Ms. Stephanie Barwise to make an opening statement on behalf of those bereaved survivors and residents whom she represents. Now, Ms. Barwise, can you tell me whether you are in contact? Can you see me and can you hear me?
Good morning, Mr. Chairman. Yes, I can.
Ah, good morning. Good. Well, we're all ready to go if you are.
Fantastic. Thank you.
So take your time and make your statement when you're ready.
Thank you. And good morning, Ms. Istefan and Mr. Akbor. You have our written submissions on all 3 topics within Module 3. I propose to address you on aspects of topics 1 and 2, but will first summarise the module and its themes. Module 3 is a tale of lessons unlearned despite the teaching of successive fires. The failure of the physical and managerial controls at Grenfell, which should have mitigated the extent of fire, was as predictable as it was preventable. Central to ensuring these controls are adequate are the fire risk assessments required by the Regulatory Reform Fire Safety Order 2005, which should have informed RBKC and TMO of the measures required to mitigate fire and to facilitate evacuation. The principal managerial failures at Grenfell included a failure to identify the occupancy profile, coupled with a lack of any emergency or evacuation plan, still less evacuation plans for the disabled, PEEPs. Weaknesses in the physical controls, such as compromised compartmentation, including defective fire doors, rendered the stay-put strategy lethal and impacted the means of escape. These failings materially contributed to the extent and severity of the disaster. The bereaved survivors and residents from whom the inquiry will hear are but a few of the many residents who made up a richly diverse community. Their diversity is highly relevant to Module 3 issues, since age, disability, and ability to read English are all factors which should have informed both the assessment of the degree of risk and potential harm posed by fire, and accordingly, the fire safety measures at Grenfell. A significant proportion of residents suffered from some form of disability or were vulnerable, which should have been addressed when considering the means of escape and evacuation strategy. Both TMO and its fire risk assessor, Carl Stokes, failed to identify vulnerable residents at Grenfell, despite this being a recognised parameter in fire risk management, as the risk profile of a building is a function of its occupancy and fire growth rate. There is no evidence that TMO assessed the needs of any vulnerable person in Grenfell in the event of fire. This failure resulted in TMO not recognising the fire precautions required to protect vulnerable residents and failing to advise LFB of the need to assist the vulnerable. The lack of appropriate precautions is reflected in the deaths. Dr. Lane calculates that a quarter of the 67 child residents present on the night died, and 41% of the 37 vulnerable adult residents died. These groups suffered higher death rates than any other on the night. Yet TMO's spreadsheet emailed during the fire showed only 10 residents with disabilities out of 225 listed. In this respect, Grenfell shines a light on an aspect of fire safety crying out for reform. Dr. Lane considers there is an urgent need for guidance and focus on the fire risk assessments, or FRAs, for the vulnerable in the event of fire. Three key themes which span across the topics which the inquiry will wish to explore include, first, RBKC's leadership, culture and purpose insofar as they influenced fire safety and engagement on that subject with residents. Second, RBKC's scrutiny of TMO, and third, TMO's fire safety management. Starting with the first theme, RBKC's leadership and its influence on fire safety. RBKC's prioritisation of cost over fire safety is a contributing factor to the extent of the disaster. Appointing TMO as an arm's length management organisation, or ALMO, did not relieve RBKC of its common law duties as landlord, nor of its statutory duties, including responsibility under the fire safety order. RBKC's failure to show leadership and adopt a rigorous approach to fire safety management inevitably affected TMO's approach. As Lord Cullen found in his Ladbroke Grove rail crash inquiry report, a successful safety culture depends upon the leadership driving that agenda. It has long been clear, as stated in the 2007 Good Governance Framework, that it is the role of a local authority's leadership to clearly articulate its vision of its purpose and intended outcomes for its citizens. RBKC accepted this principle by its 2014 by-borough corporate fire safety policy, which expressed its desire to champion fire safety through strong, visible leadership. Far from championing fire safety, RBKC prioritised cost over safety on leaseholder doors, door closers, and sprinklers. It seems if the LFB had made a firm recommendation or requirement for sprinklers, RBKC would have considered it. This is to misunderstand that the fire safety order required RBKC to make its buildings safe for the residents. Thus, different buildings require different measures. RBKC failed to prioritise fire safety and refurbishment, despite the Lacknell House coroner's 2013 recommendations. RBKC's leader, Councillor Paget Brown, failed to implement the LFB audit tool sent to him in 2015, which was specifically designed to ensure refurbishments did not impact fire safety and had been designed by the Lakanal House Working Group for adoption by councils. This criticism does not derive from mere hindsight. RBKC was aware of the Lakanal fire issues from July 2009 and acutely so from 2013 when it considered the coroner's recommendations. In 2014, RBKC's building control received notes on Lakanal, warning it could happen again in social housing, citing cladding and overall worsening of conditions through years of neglect. Despite these warnings, RBKC did not issue guidance to its ALMO on such matters. As late as April 2017, RBKC's Laura Johnson received LFB's letter entitled Tall Buildings, External Fire Spread, warning that cladding panels often did not comply with building regulations, were prone to delaminating, and could potentially spread fire from flat to flat. The letter urged RBKC to address how it achieved compliance and consider this issue as part of the risk assessment process for premises under your control. RBKC failed to investigate how TMO ensured compliance of facades, but contrary to LFB's advice, RBKC also failed to require that facades should be included in future fire risk assessments. This despite Grenfell's recent refurbishment and it being one of RBKC's highest risk properties. Instead, RBKC forwarded LFB's letter to TMO without instruction, simply FYI. This lack of proactivity is extraordinary in a project RBKC witnesses describe as a big deal, widely seen as a positive thing by RBKC officers. Only after the fire did RBKC issue a draft fire safety management system, which finally acknowledged the need for housing management to comply with existing guidance by preparing fire strategies for existing buildings in accordance with PAS 911 and put in place a robust system of fire risk assessments to industry best practice under PAS 79. The failure to require such strategies and systems before the fire is a serious failing, given Dr. Lane's opinion that it is impossible for the responsible person to discharge their fire safety duties without an existing fire safety strategy, which would inform the significant findings in FRAs. The inquiry will need to determine the question whether both RBKC and TMO were responsible persons under the fire safety order. Both qualify since, as occupier or otherwise, both have significant control in the carrying on of an undertaking, namely housing provision. TMO's fire safety strategies consistently from October 2012 to June 2017 described itself and RBKC as both being responsible persons. As from 2010, LFB regarded RBKC as a responsible person. RBKC acknowledged its responsibility as a responsible person by participating with TMO and LFB in the 2009 programme to improve fire safety of RBKC's stock. While TMO had day-to-day control, RBKC had ultimate control, since TMO's funding entirely derived from RBKC. The second theme is the quality and degree of RBKC's scrutiny of TMO. Although RBKC delegated various functions to TMO by virtue of Section 27 of the Housing Act 1985, right to manage regulations and form of agreement approved by the Secretary of State under those regulations, namely the Modular Management Agreement or MMA, RBKC's legal relationship with its tenants or leaseholders and its statutory, contractual, and common law obligations towards them remained. RBKC was obliged to scrutinise TMO's exercise of those functions delegated in order to ensure compliance with the fire safety order and the Council's common law duties. RBKC also had a scrutiny function under the Localism Act 2011. The 4 core principles of good scrutiny proposed by the Centre for Public Scrutiny provide for critical friend challenge, enabling the voice and concerns of the public in a process led and owned by independent-minded counsellors, which drives improvement in public services. RBKC's principal vehicle for scrutiny of TMO was the MMA, but it lacked specificity as to the degree of monitoring RBKC was entitled or obliged to carry out. The key mechanism for scrutiny under the MMA was the setting of key performance indicators, or KPIs, but RBKC failed to ensure there were KPIs governing safety, despite fire safety always being a pressing criterion for RBKC, given the vulnerable tenants it housed. This link between vulnerable tenants and fire outcomes is enshrined both in British standards governing the design and use of buildings and other guidance. The failure is also surprising given RBKC mooted accessibility for the disabled as a possible KPI in an internal email in 2009, noting there are some serious brownie points to be gained in all this, as members understandably feel very strongly about disability and meeting need. The failure to ensure fire safety KPIs were in place is all the more extraordinary, given that, as RBKC knew, TMO was proposing KPIs for fire for its own monitoring purposes from 2015 onwards, albeit they were never in fact implemented. RBKC admits, as Counsel Inquiry has said, by its opening submissions, that it should have imposed KPIs on TMO for FRAs and work required under them. There was an appearance of scrutiny, but it lacked substance. RBKC's yearly and half-yearly reviews of TMO's compliance with KPIs were based on reports, the vast majority of which RBKC now admits were written by TMO. This was also true of the health and safety reports, which TMO's health and safety advisor Janice Ray had prepared, thereby marking her own homework. RBKC candidly admits that this fact was not made clear to those scrutinising and should have been. RBKC also admits that the number of officers devoted to monitoring TMO was insufficient, given the scale of the task delegated to TMO, and that in certain key respects, RBKC's monitoring of TMO was not carried out in accordance with RBKC's own monitoring procedure guide. RBKC also admits that it failed to convene the 6th weekly meeting with TMO's complaints team. RBKC was aware, at latest from 2010, of its responsibility to take a hands-on role in fire safety rather than simply relying on paper briefings from its ALMO. RBKC endorsed a note called Extinguishing the Risk, a counsellor's guide to fire safety, at a scrutiny meeting in 2010. That guide made clear that a council's responsibility, whether for retained stock or via an ALMO, was the same as any other landlord, namely that the council needed to ensure the fire strategy was being taken seriously and FRAs done competently. The scrutiny committee recorded that the guide reflected the expectations on this council. The third theme is TMO's fire safety management. The adequacy of this requires close examination. The responsibility for fire safety across RBKC's entire estate of some 9,400 properties rested on Janice Ray as Health and Safety Manager. Dr. Lane considers Ray should have been capable of designing and delivering a fire risk management system, and if not, should have sought assistance. While Lane finds TMO's policy documents did address some relevant fire safety objectives, they failed to plan how to achieve their policy intent. Critically, TMO failed to identify its intent in relation to occupancy profiling, and although some monitoring was done, there is no evidence that this was done to inform the RFAs. Furthermore, TMO failed to articulate its intent as to the implementation of general fire precautions and control of construction work. As a result, these activities were haphazard. These fundamental failures were compounded by TMO's reliance for all aspects of fire safety advice at Grenfell on a single risk assessor, Stokes, who lacked any professional registration and invented some of his professional qualifications. TMO was overwhelmed by the sheer volume of outstanding FRA actions due to its failure to address how they should be actioned. As a result, it sought to deliberately conceal this from RBKC. TMO's focus on completion of our FRA action items without monitoring the level of risk posed thereby is a critical failing. This problem originated with Stokes, whose FRAs did not state the impact on risk if TMO failed to undertake the actions he identified within the required timescale. In turn, Stokes failed to interrogate TMO's fire safety management or maintenance regime, which meant that his opinion of the consequences of a fire and overall risk level could never be accurate. Critically, TMO failed to monitor Stokes's activities, despite being aware that a different fire risk assessor in 2014 had taken a different approach, giving Grenfell a moderate as opposed to tolerable risk, pending resolution of his action items. This should have alerted TMO to Stokes's failure to evaluate the risk posed by outstanding FRA items. Stokes's failings were absolutely plain by the time of the Adair fire in 2015, and Ray received various criticisms of him in 2016 and 2017, yet TMO failed to question the performance of the risk assessor on whom they were very heavily dependent. As to the first topic, complaints, a functional complaints process is a key element of the 4 core principles of scrutiny I've already mentioned. Complaints help inform management of true performance. TMO's and RBKC's dismissive attitude towards residents' complaints was symptomatic of their approach to governance, which led directly to the devastating failures of controls at Grenfell. TMO avoided classifying expressions of dissatisfaction as complaints, characterizing them instead as service requests. The complaints policy contemplated an investigation procedure of up to 3 internal stages, creating the illusion that complaints would be considered afresh at each stage, whereas in fact, responses to complaints were drafted by those complained about, but sent out by others in TMO, giving a semblance of impartiality. The first 2 stages were subsequently amalgamated following instructions from TMO's CEO, Robert Black, in 2014 to make sure we are all on the same page. Residents considered the process unduly cumbersome and difficult to navigate. During the refurbishment, residents were initially referred to Ryden before engaging TMO's own process, such that, as TMO's then complaints manager, Joanne Burke, noted, by the time that they get to the complaints team, they are thoroughly fed up. Burke also felt that there is a defensive culture in the capital team about complaints. TMO's approach disincentivized complaints. Madison's descriptions of closing down, closing off, or shutting down complaints reflect TMO's strategy of merely dealing with complaints, but without genuine consideration. Resident concerns were dismissed as rhetoric. Madison dismissed Duffan and O'Connor's gag blog as scaremongering. Following a resident's petition in 2015 asking RBKC to exercise scrutiny, TMO, in collusion with RBKC officers and councillors, engineered a situation where TMO could deal with itself and avoid scrutiny by RBKC. The resulting TMO board report lacked independence and failed to address residents' complaints. TMO briefed councillors against residents, making clear complaints had been rejected, were without foundation, and suggesting residents had acted unreasonably. This concerted effort to manage councillors' perceptions of TMO came from the top. It was led by Black, who cultivated a relationship with RBKC's Laura Johnson, which gave him advice and influence over councillors. Johnson's March 2017 email in response to Black's about a post-refurbishment complaint, in which he characterised the complaint as an echo of the fight we have been in for the last 2 years, epitomises her advice and her negative attitude towards Grenfell residents. She said, "Be robust to Councillor Fielding Mellon. He's not minded to attend a public meeting with a group of people who are moaning about minor issues. He is fully aware about Eddie Daffan, so you can rest assured he is not taken seriously." This doesn't go back 2 years. This goes back 20 years. It has always been a bad-tempered place, and for some reason that general crossness has lingered and is stoked by various individuals with their own agenda. Understandably, residents were not fire safety experts, but they did identify 3 important issues which should have alerted TMO to an obvious threat to Grenfell's fire safety. First, the replacement riser in the stairwell. TMO procured the installation of the riser by National Grid following a leak in a gas riser in 2016. Between March and May 2017, residents, including Lee Chapman, Secretary of the Grenfell Tower Leaseholders Association, voiced concern about the fire safety of installing gas pipes in their only escape route and repeatedly asked that an independent expert be engaged. These concerns were well-founded. TMO had been warned by Stokes's letter in January 2017 to ensure that compartment penetrations were sealed and that an application to building control for the works was required. Yet both RBKC and TMO instead relied on vague assurances of compliance. Resident concerns were dismissed with derision, epitomised by Laura Johnson in March 2017. Lee Chapman had given Johnson and Black a clear and correct warning that as a result of the installation, the building's integrity has been compromised. Mr. Chapman's email also alerted Johnson and Black to Grenfell's vulnerable residents. There are many people in this building who are immobile, very young, or suffer from mental health issues. A moment's reflection, particularly in the wake of Lacanau, should have caused these senior figures in TMO and RBKC to reflect on the possibility of compartment breach and should have served as a timely reminder of the needs of vulnerable residents which had not been addressed. Instead, Johnson told Black, "When the pipe issue has gone away, they will find something else to write about." Second, reports of broken door closers or damage to seals on flat entrance doors should also have alerted TMO, yet did not. Daffan's complaint in August 2015 that flat 136's door had been left open all weekend and had a broken door closer was met with the suggestion that he simply close it. TMO considered the issue resolved. This overlooked the fundamental problem that open doors equate to breached compartmentation. Betty Cassotti and others record that when their doors were reported as difficult to close, TMO's repairing contractor simply removed the closer. Third, the lift. Although residents' complaints, including those with disabilities, concerned the inconvenience of breakdowns rather than safety and fire, these complaints were obvious alerts to the dependence of those with disabilities on the lift. This should have triggered further investigation as to the use of lifts as evacuation lifts and the need for PEEPs. Turning to topic 2, the fire safety order imposes a requirement that a building, regardless of age or compliance with regulations, be safe for the relevant persons, namely residents and visitors. This is achieved by procuring FRAs to identify the preventative and protective measures required to keep relevant persons safe. An evacuation plan is necessary in certain circumstances, such as compartment breach. Regardless of the evacuation strategy of the building and including if it is stay put. The inquiry will wish to address how it is that one of the principal pieces of guidance applicable to purpose-built blocks, approved by the Secretary of State, detracts in key respects from obligations imposed by the order. This LGA guide was sector-led and albeit produced in the wake of Lacanau, fails to require an evacuation strategy and assumes that PEEPs are not required in general needs blocks. The guide also created the concept of a notional FD30 door, namely one with an assumed fire resistance of 30 minutes, and suggested it was not practical to destructively test a door in order to establish the actual fire resistance of doors for which no certification now existed. This ran counter to other post-Lacanau guidance by the Leasehold Excellence Network. Despite incorporating PAS 79 by reference, the LGA guide runs counter to PAS 79 methodology for preparing an FRA. The inquiry will wish to explore the divergence of its two experts, Dr. Lane and Mr. Todd, as to the adequacy of Stokes's FRAs and on the topic of legislative requirements for people with disabilities, on which Todd's views are at odds with the requirement of the fire safety order. Todd's vindication of Stokes is, we suggest, unlikely to withstand scrutiny and begs the question whether the competence standard for fire risk assessors is far too low. Dr. Lane concludes that Stokes erred in four key respects. First, failing to identify the occupancy profile of the building, which is both a failure to identify the relevant persons and a failure to evaluate the risks to those persons and necessary mitigation. Second, failure to link his proposed corrective measures to the risk they posed if not cured. Third, failure to probe TMO's fire safety management in order to evaluate the risks. Fourth, failure to request and review the emergency plan for evacuation. These failures meant he failed to assess the risks posed by Grenfell to residents and visitors, and his risk rating of tolerable should have been intolerable. Stokes's treatment of the facade was also flawed. While there is a debate as to whether a risk assessor must assess the facade, given that the fire safety order does not define the external wall as a common part, both Schedule 1, Part 3 of the order and the approved methodology, PAS 79, require risk assessors to evaluate the risks which cannot be avoided. That includes factors such as combustible facades, which should be included in the significant findings. In any event, Stokes, by his FRAs, purported to have assessed the cladding, describing it as fire-rated, a meaningless term, but he also suggested compliance with building regulations. It is now clear from Stokes's statement that he did not know what the composition of the cladding was and therefore had not assessed the risks posed by it. Stokes's treatment of lifts was deplorable. In 2009, he reported that he didn't know whether the lifts were firefighter or evacuation lifts, but his 2010 and all subsequent FRAs described both as evacuation or firefighter lifts, which could be used to evacuate disabled residents. This despite Stokes having been told that TMO's senior lift engineer did not consider the Grenfell lifts to be firefighter lifts. Again, Dr. Lane and Mr. Todd's opinions are in sharp contrast. While both agree Stokes did not understand lift standards, Lane considers his failure to recognise the lifts were not firefighter lifts resulted in the loss of a vital opportunity to identify necessary mitigating measures. Todd, however, considers Stokes's lack of knowledge of lift standards does not detract from his competence as a fire risk assessor, and that the lift's design did not affect the risk to relevant persons. That is unlikely. Had the lifts been firefighter lifts, either no key at all would have been required, or an emergency unlocking triangle key would have been required. And in either case, it would not have been possible to use the incorrect key, which Hawkins tentatively concludes is most likely what happened. At least 3 lives might have been saved. Perhaps Stokes's most egregious failing was not to ask for an evacuation plan or address the lack of PEEPs. Instead, he repeated for 6 years that data would be inputted into a TP tracker with a view to preparing PEEPs, but as he knew, he had not been asked to prepare PEEPs for Grenfell. Lane considers he should have been proactive in obtaining such information. RBKC and TMO's principal failures as the responsible persons related to fire doors and failures to facilitate evacuation of the disabled. TMO's fire risk management suffered from systemic failures, despite TMO being told in 2009 that it was in statutory breach on almost half of the procedures reviewed. The review advised TMO it needed a fire safety policy, setting objectives for compliance with the fire safety order. TMO suffered from a lack of transparency, which meant it lauded itself as having been given a clean bill of health by external audits in 2013, even though those audits had alerted TMO to its poor management systems. TMO did not have proper structures in place to address the volume of action items arising from FRAs, but rather than resolving the issues, resorted to cleansing the revealing data. This lack of transparency resulted in the FRAs not being a reliable review of TMO's system and not assessing risk. TMO's systems did not encourage learning lessons or change. Although Borough reported to the TMO Health and Safety Committee concerning fire safety by high-level exception reports, these were not shared with the TMO's board, and therefore there was no mechanism for making changes to the fire risk management system. As to doors, RBKC sought from 2011 and still ongoing in May 2017 to avoid using its powers under the Housing Act to ensure leaseholder doors were compliant, and instead sought to persuade LFB to prosecute leaseholders under the fire safety order. RBKC clearly recognised it was in breach of the fire safety order as it made a submission in 2013 to the Secretary of State acknowledging 68 potentially non-compliant doors, and jointly with TMO obtained advice from Counsel, which apparently suggested TMO's notification to leaseholders of non-compliance constituted due diligence, namely a defence to successful prosecution under the order. Despite being acutely aware that defective doors mean compartmentation breaches, RBKC's approach was to cynically calculate potential cost versus the cost of replacing leaseholder doors. In an email in which RBKC's Roger Keane had noted there was no realistic prospect of Southwark being criminally prosecuted for Lacanal, he said, "If something did happen at one of our properties, we are still likely to be the organisation that faces prosecution. We therefore have to weigh up the potential cost of dealing with this issue against the situation we would face if something happened and we were found liable. There can be no room for any form of cost-benefit analysis, given RBKC's obligation to keep the protected routes safe and given lives were at stake. Even as late as May 2017, when councillors suggested RBKC should replace leaseholder doors at Trellick Tower, regardless of whether they would be reimbursed, Laura Johnson overruled them, describing it as a non-issue. This demonstrates a staggering lack of concern, only tolerable in a culture with scant regard for safety. TMO also knew it was in breach of the order and had been advised by Stokes that landlords were being prosecuted for non-compliant doors on the protected route. It seems RBKC's and TMO's focus was on avoiding liability instead of on fire safety. RBKC was similarly irresponsible in relation to the absence of door closers. Cost management took priority over safety. RBKC did not decide to instigate a door closer installation programme until March 2017, despite understanding from as early as 2009 the criticality of door closers to the stay put policy. In October 2015, a serious fire occurred at Adair Tower, in which the flat of origin's door failed to close due to the lack of a door closer, filling the lobby with hot gases and heavy smoke, resulting in 24 fire survival calls, and in that respect, resonant of Lacanal. A deficiency notice had been issued prior to the fire, identifying a failure to address the absence of self-closing devices. Thereafter, enforcement notices were issued in 2015 and 2016 on Adair and Hazelwood towers, including for failure to fit door closers, and a deficiency notice was issued on Grenfell in November 2016, again for failure to fit door closers. RBKC therefore had full knowledge of the extensive fire risks posed by the lack of door closers, yet failed to commit to install closers across its estate until nearly 2 years after it had seen the serious consequences of this omission. No door closer programme was in place by the time of the fire. RBKC now accepts that an installation programme should have been in place before then. At the 1st of March 2017 meeting, at which Laura Johnson gave approval for a door closer installation programme, she pushed the installation of closers from a 3 to a 5-year programme to, quote, make the funding of the programme more manageable. At that meeting, she is recorded as agreeing to hold off recommending inspections programme at present, not being convinced of the need for an inspection programme, which, in her own words, would have to be ongoing and therefore an additional expense to the housing revenue account indefinitely, without any identifiable evidence that it impacted positively on the fire safety of residents. This was a misguided and perverse perspective, given that 2 years earlier, RBKC had at Adair witnessed the best evidence of the devastation which ensues in fire if a door fails to close. RBKC now accepts that guidance required regular inspections of door closers. Regardless of whether the decision not to instigate an inspection programme emanated from RBKC or TMO, both parties are equally at fault. TMO had been warned by Stokes in 2011 that the removal of door closers on the protected route was placing relevant persons at risk of death or serious injury in fire. If a reminder of this were needed, then the 2015 Adair fire. Nevertheless, even faced with prosecutions on Adair, Madison resisted the installation of door closers at all properties and instructed Counsel to consider whether they were only required where fundamental to the fire strategy, and wondered, how can we best transfer responsibility for maintenance of door closers onto the tenant? Both RBKC and TMO failed to ensure the required means of escape for the disabled, despite RBKC having originally been a trailblazer for accessible housing and being aware that inclusive design requires that buildings must cater for all. As RBKC's Claire Wise said in 2010, specifying that disabled people should not live above ground floor is an unacceptable acknowledgement that existing fire safety procedures are not inclusive. TMO consulted with an access consultant and obtained a report addressing wheelchair access and door closers for those with limited upper body strength, but ignored these considerations, despite being made aware in 2017 that new doors at Grenfell were too heavy for the elderly or disabled. As TMO had no policy for identifying the needs of the disabled or processes for achieving the necessary protective measures, there were no such measures. In conclusion, the failure of controls at every level requires a thorough examination of the ambit of the order, associated guidance, and the competency requirements of fire risk assessors. The order requires that buildings be safe and accessible to residents and visitors, and to that extent neuters the provisions of the building regulations which do not require retrospective change. Nevertheless, the inquiry may wish to address the adequacy of ADB, which, albeit premised on inclusive design, offers limited guidance on the topic. The multiple managerial and systems failures at Grenfell, which also include inadequately fire-rated doors, systems maintenance failures, and inability to rapidly isolate the gas supply during the fire, speak in favour of a safety case covering all aspects of a building's safety, which could be audited by those with the relevant specialist knowledge and available to emergency services. Those are my submissions, sir.
Well, thank you very much indeed, Ms. Barwise. There's a lot for us to think about there. and we're very grateful to you. Thank you very much. Well, now it's time for me to invite Mr. Friedman, Queen's Counsel, to address us and make an opening statement on behalf of the same group of bereaved survivors and residents. So, Mr. Friedman, are you in touch with us? Can you see me? Can you hear me?
I can, sir. I hope you can hear me.
Good morning, Mr. Friedman. Yes, certainly you can.
And good morning to you and Miss Estefan and Mr. Akbor.
Well, now we're running slightly ahead of time, but there's nothing wrong with that. And if you're ready to make your statement, then please carry on.
I am. We address you especially now on behalf of two groups of Bat Murphy Court participants. First, those who campaigned for a greater voice and agency in matters relating to their homes and safety, which they were knowingly denied. Second, those who lost relatives whose disability or vulnerability meant that they could not escape without pre-planning and provision, as was foreseen before the fire, but nothing was done. We want to particularly draw your attention to the significance of the organisational and cultural context, and to consider that part of the disaster which was the product of imbalance of power and disregard of the vulnerable. The inquiry has reached the point where the causal role of these inequalities cannot be ignored consistently with its terms of reference. The missing fire safety measures were not just in the dangerously defective construction and lack of compliance, but in defective political and administrative systems that no less significantly failed to prevent this unprecedented mass fatality. The political and administrative context under RBKC and the TMO is dealt with in part 2 of our written submission. We take it as a given that you will study and report on the legal, contractual and regulatory structure that these organisations acted under. But we want you to reflect on the way they behaved and why that was so. Starting with the TMO. On paper, it declared, we keep residents at the centre of everything we do. It committed to giving them maximum involvement in areas like major improvement works. In practice, resident participation was at most tokenistic, or more often suppressed whenever there was disagreement. As a social housing manager, the TMO was large and powerful. It presided over nearly 10,000 households across some of the most expensive real estate in the world. Its size and monopoly had no equivalent across the United Kingdom. The TMO was not a democracy. The number of members who voted for it to continuing managing RBK's housing stock at each AGM throughout the relevant period was on average never more than 10% of the households under its powers. The TMO had a single client and patron, RBKC. It treated the council as the boss, its chairperson's word, not mine. If anything was centre stage, it was the wishes of the RBKC. And you will see this dynamic was exacerbated during the Grenfell refurbishment project. RBKC was the product of the leadership of the governing party that had led the borough for generations. Panel, the wisdom of different approaches to social housing policy may be for other forums, but you don't need to judge the politics in order to examine the causative effect of values and ideas. If the inquiry finds that an ethos of indifference or hostility came to permeate the non-negotiable matters of fire safety, as all the evidence suggests it did, then it must surely say as much. A key to the terrible handling of the Grenfell refurbishment lies in its deeply ambivalent origins and motivations. The project was from the outset a reluctant concession to vocal residents who drew the politically inconvenient contrast between the expenditure on the school and sports centre on their doorstep and the dilapidation of their estate. Conceivably, it only ever got the green light from RBKC because it was thought to mitigate the perceived blight Grenfell cast on the Calc neighbouring investment. Its cladding facade was sold as a combination of aesthetic and environmental progress, which it seems served to remove the need to ask about dangers and downsides. The investment needed to be sold to those who saw these units not as homes, but as assets in the context of an identified £30 million funding shortfall in the ring-fenced housing revenue account. Grenfell was considered one of RBKC's worst performing assets, presumptively to be knocked down, not refurbished. Lucrative mixed housing regeneration was identified by RBKC as the solution to the funding shortfall. The TMO believed, with a degree of existential anxiety, that it had to prove itself to RBKC as able to deliver on such ambitious regeneration projects for fear of being replaced by someone else. The TMO's desperation for, in Peter Madison's words, a seat at the table on such future projects made it hypersensitive to the preferences of its single client. Meanwhile, RBKC left the TMO in no doubt that its priorities were delivery on time and in budget, and not resident satisfaction and safety. That is all essential context for how the authorities behaved in the face of criticisms that were made by residents who campaigned to be treated as equals in planning, procurement, and scrutiny of the refurbishment. They tried and failed to take on RBKC and the TMO with regard to the defects and dangers in the works that they could see. They did everything they could to compel transparency and accountability for the things that were not shown to them. The defeat of the residents' campaign for accountability is dealt with in part 3 of the written submission. It was achieved through a systematic and concerted denial of residents' entitlements to be consulted, informed, and listened to. Modern administrative law established basic standards for any consultation exercise undertaken by a political body and provides a measure to judge RBKC and the TMO in this case. These standards serve the valuable purposes of both improving decision-making by properly testing proposals and avoiding the legitimate sense of injustice arising from denial of a fair opportunity to influence an outcome. To serve these purposes, consultation must occur at a formative stage of relevant decision-making, provide sufficient time and information to enable intelligent response. The decision-maker must then conscientiously and with an open mind take into account what they are told. Schedule 3 of the Modular Management Agreement between the TMO and RBKC and Section 7 of the TMO's Contracts, Regulations and Guidance mandated that any major works project should include consultation, involvement and oversight by affected residents. The duties under Schedule 3 contain specific prescriptive requirements for close involvement of a relevant residents association that was entitled to establish a client review group to in effect act as the client. This gave it representation on the project team, involvement in the decision to appoint consultants, including architects, and attendance at site meetings to ensure, quote, that tenants' concerns are addressed. What is plain is that the TMO, supported on this by the RBKC, were entirely opposed to a residents' association being permitted to scrutinise the Grenfell works. And we have asked you to look at how these residents' rights under the Foundation TMO documents were deliberately stonewalled and frustrated over a number of years. The counterfactual exercise of just imagining a proper consultation on procurement and the works in this case is a powerful thing. The architects, Studio E, were appointed without tendering or establishing their experience and competence. They have told you themselves in their evidence that had a proper procurement exercise taken place, they should not have got the job. Residents were simply told of their appointment after the event. They immediately queried it, but were brushed aside. Neither was there any meaningful consultation on the appointment of Ryden as the main contractor. When the suggestion was raised internally with the TMO that it was necessary to involve residents in the March 2014 tender interviews, the response was to ask if this was some kind of a joke. That pretty much says it all. You will see that resident involvement was deliberately kept to the absolute minimum. The evidence in Module 1 and 2 has shown you that there is an inextricable link between the appointment of Ryden and cuts that were made to the tendered budget, leading to the downgrade in cladding material. Sir, the simple fact is that no properly informed resident, given the opportunity to choose between Renabond ACN and the slightly more expensive Zinc FR, would ever have opted for the cheaper version without at least asking the question, what are the downsides? Grenfell residents, of course, were never given the opportunity to ask. As a matter of organisational culture, the TMO had a fundamentally misconceived understanding of the purpose of resident engagement. The primary aim was to achieve what it called buy-in and support for the project. It countenanced a joint approach with RBKC to keep concerns in-house. The overall outcome of this approach was that managers, experts, and contractors dominated to the exclusion of residents. Laypersons, particularly residents, were treated as having little or nothing of value to add. Therefore, no right to comment on budget, no right to ask about potential negative consequences of substituting materials for reasons of costs, no right to quiz the credentials of a would-be architect or main contractor, no rights, no utility, no dignity in relation to what was being done to their own homes. But you will also see from the evidence that the TMO deliberately withheld important information with the bad faith intention to cover things up. On the 30th of October 2014, Edward Duffan requested minutes of monthly project meetings between Ryden, the TMO, Studio E, and others. The application was disingenuously refused by blanket invocation of commercial sensitivity. This was not a one-off. As we address in our written submissions, it was part of a wider practice of deliberate misuse of the commercial confidentiality exception, a practice persisted in despite a complaint upheld by the TMO's company secretary and legal advice given to the TMO on the proper approach. What was the real reason? Claire Williams recorded it in terms in respect of Mr. Daffan's October 2014 request. It was to avoid critical scrutiny of problems. She cited, among other things, problems of residual asbestos in flats and what the TMO's own contractors described as the bombshell of residents remaining unprotected due to a non-functioning ventilation system, despite an LFB deficiency notice. Claire Williams advised that knowledge of these problems would, quote, cause Mr. Daffan to raise more queries either on his blog or via further freedom of information requests. Panel, we say the October 2014 refusal to provide information is a genuine what-if moment. By the summer of 2014, Edward Daffan and Francis O'Connor had posted a blog of a letter to Ben Dewis of the local LFB to say that, quote, residents of Grenfell Tower do not have any confidence that our building has been satisfactorily assessed to cope with the new improvement works. The TMO sought and still seeks today to characterize the blog as alarmist. But what was known to the TMO but undisclosed to residents is by that time, Exova had produced 3 editions of a draft outline fire safety strategy for the refurbishment, all of which expressly left the question of potential external fire spread to be answered in a future issue of the document. No such issue ever came. When GAG then made the October request for information, 5 consecutive monthly project meetings had tasked Simon Lawrence of Ryden with formally appointing a fire consultant, but nothing was done. On seeing those minutes, residents could have insisted on a final report being prepared to complete what Exova had obviously left unfinished. Yet further, also in the autumn of 2014, Carl Stokes produced a high priority action plan, which was never disclosed to residents or, it seems, the LFB. This required Ryden to detail the fire rating of the cladding and the fixings and obtain confirmation of the building control officer's acceptance of this fixing system and the cladding used. This too was not properly actioned. Drawing it all together, the Grenfell Action Group, which had already queried whether the fire safety of the refurbishment had been properly assessed, was denied critical information demonstrating that it hadn't. Edward Daffan and the TMO could at least agree on one thing. If the Grenfell Action Group had found this out, of course they would have publicised it, and of course they would have asked more questions. Instead, they and others who survive must live with the fact that they were denied the opportunity to keep themselves and their homes safe. Many of the BSR have shared experiences in their inquiry statements of how the TMO rejected, diminished, and managed residents' concerns and complaints. As Dr. Lane describes it, resident interventions were, quote, seen as a hurdle to get over, a paperwork problem to close out, such that time and time again, when the proper opportunity arose, the potential risk to life was not evaluated. One strand of this failure to listen was an obsessive defensiveness towards Edward Daffan. In August 2015, when he reported the door to flat 136 on the 16th floor to be wide open because its self-closing device was broken, it seems that the TMO really did care more about dismissing his complaints than just fixing the actual door. The door did not automatically close when Hamid Wabi moved into flat 136 in February 2016. On the night of the fire, the door still did not self-close, causing smoke to fill the lobby. Joseph Daniels and Sheila died on that floor. Edward Daffan survived only because he was dragged from the lobby by firefighters. People coming down the stairs saw smoke filling their path, most likely from floor 16, and we know that this is one of the reasons why they then went back upstairs to their death. So criticism can be a good thing, and it certainly was at Grenfell, given the extent of the dangers that were being incubated by neglect. For the TMO to withhold information because they did not like what their critics would do with it was unlawfully perverse and a patent abuse of power. It is remarkable and telling that the TMO, after everything, still seeks to perpetuate their criticisms of Edward Daffan in their opening submissions for this module. That is indeed the advocacy of a non-functioning, amoral organisation that was and is more interested in its reputation than keeping people safe. At the beginning of 2015, there was a building-wide anxiety about the refurbishment and opposition to how residents were being treated. Rather than engaging with it, the TMO did everything they could to deny it. By March of that year, residents across the tower of all backgrounds, ages, and interests have come together. They asked to be recognised as a more formal entity, supported by a letter from the trade union Unite. There are poignant pictures of their meetings across that year that show a number of women and men who died in the fire, as well as several survivors that the inquiry has come to know. The response of Robert Black, the CEO, to that Unite letter was to make clear his and the TMO's preference to not even nuke the group because he regarded it as a showcase for Mr. Daffan. In December 2015, the same group lodged a petition with RBKC. The initiative involved Councillor Blakeman, who had come to support its aims. The document was signed by 60 residents. It called for urgent independent investigation by the RBKC Housing and Property Scrutiny Committee of the conduct of the works and the treatment of residents. Of those 60 signatories, 20 either died in the fire or were bereaved. Again, despite the number of signatures, the evidence of residents' views was still apparently dismissed within RBKC and the TMO as somehow unrepresentative due to it being organised or engineered by Edward Daffan. Among many other fallacies with this critique, it discounted that the signatories genuinely believed what they had put their name to, or that there could be any value to what they were saying. What followed before the scrutiny committee was a further shameful lost opportunity. Rather than commissioning an independent investigation, the TMO, council officers, and the committee orchestrated the outcome to allow the TMO to investigate itself. The TMO duly reported back, despite Councillor Blakeman's efforts to correct its errors and omissions, in a document that was originally classified, which dismissed residents' concerns in their entirety without interviewing a single resident, and instead glowingly commended itself and its contractor. This was not Edward Daffan charting his own path. He was there alongside many. To name just a few, there was Willie Thompson, Mariam El Houari, Dennis Murphy, Berkty Hafton, and Sheila, who told me to Peter Madison in a meeting, I am here because I am a vulnerable person. There was leaseholder advocates like Shah Ahmed and Tunde Owadero, residents with a pertinent professional background to see what was going wrong, like David Collins. And there was Judith Blakeman, as an elected councillor and TMO board member who was increasingly bullied for supporting these people, even though that was her job, and the TMO was supposed to be resident-led and resident-centred. The TMO took her words at face value when it suited them and marginalised her when it didn't. Panel, organisational exclusivity and disregard for non-member input is a classically understood feature of human-made disasters. And this is a textbook case. The outsider is dismissed as a crank, a misfit, or a manipulator of others. The stigmatization of the dissident creates a blind spot to the criticism being made. They did this to Ed Defan, but don't for a moment think that they didn't do it to Shah Ahmed, David Collins, Judith Blakeman, and anyone else who told them that they were wrong. But to make matters worse, there was an irresponsible assumption that anyone else was either being supinely led by these critics or otherwise content. It ought to be obvious to anyone involved in social housing that residents may be reluctant to complain personally for a multitude of reasons, including but in no way limited to immigration or housing status or experience as a member of a minority race or ethnicity. They must be entitled to rely on collective advocacy rather than given the invidious choice of bearing the burden of speaking up alone or being silent or indeed silenced. A functioning system of governments committed to listening without prejudice to its residents needed to be conscious and responsive to this in a way that the TMO and RBKC were deliberately not. In the end, even the most fearless of residents could only address on fire safety what they could see or were told about. As a result of the deliberate withholding of information, they were sometimes just able to communicate an inchoate, tacit awareness that they were unsafe from fire at Grenfell. Again, rather than respecting and acting on this, founded as it was on the intelligence of those who actually dwelt in the lived environment, the TMO took advantage of the informational deficit it had created to repeatedly dismiss residents' fears as unwarranted and unsubstantiated. Our final subject for today is the neglect of disabled and vulnerable residents that is set out in part 5 of our submission. We note with respect that all BSR submissions have made this a centerpiece of their opening. They and we have done so because although the Grenfell Tower fire is many things, it is surely a landmark act of discrimination against disabled and vulnerable people. The law does not appear to be in significant dispute. These were special categories of at-risk relevant persons to be identified, planned, and provided for by the responsible persons under the Fire Safety Order 2005. The discharge of the fire safety functions had to be informed both by the public sector equality duty in section 149 of the Equality Act and the internationally and domestically protected human rights to life and non-discrimination. None of this happened. As Ms. Barwise has highlighted, the TMO and RBKC now seek cover for the breaches of statutory duty in a few short passages in guidance developed by the sector and published by the Local Government Association in 2011. Colin Todd is an expert witness in this inquiry, but his role in formulating and perpetrating the offending advice in the guide must itself be the subject of a scrutiny. That advice states that there is usually nothing to be done for vulnerable residents in high-rise buildings operating a stay put policy because it is unrealistic to make any special arrangements for them. No serious legal or moral defense of the wholesale denial of fire safety to a class of residents, especially in need of protection, is offered in the guide or to this inquiry. Instead, first, a transparently false dichotomy between maintenance of a stay put strategy and simultaneous evacuation is floated to imply outrageously that the status quo was in fact favourable to vulnerable persons. As is plain to see, the real issue is denial of planning and provision for evacuation when it is no longer safe to stay put. Next, it's suggested that evacuation should, all being well with compartmentation, rarely be required. This is simply not an acceptable answer to the situation when all is not well, which even the LGA guide contemplates. That is why the fire safety order so clearly imposes non-delegable duties requiring planning and provision for all residents, not just those without additional needs. As it happens, the three other inquiry experts, Dr. Lane, Professor Galea, and Professor Torreira, strongly disagree with Mr. Todd regarding the limited risk of compartmentation breach in high-rise buildings as a class. Colin Todd, and those in the sector and government who agree with it, have demonstrated themselves unable or unwilling to stand back and reflect on the status quo. Remarkably, in the immediate aftermath of the Phase 1 peak recommendation, Mr. Todd and industry rushed out new draft national guidance in the form of PAS 79/2020, doubling down on the do-nothing approach and deliberately deleting positive provision for disabled and vulnerable residents found in their predecessor edition. The BSI has recently seen the wisdom of withdrawing PAS 79/2020 and reconsidering the issue, and so too the Home Office, despite initially being lobbied to contemplate a departure from the inquiry's Phase 1 peak recommendation by a sector special interest group submission that Mr. Todd had again contributed to. A major fault of the dogmatic sector stance is its lack of openness to existing and new ways to improve the safety of disabled and vulnerable residents. It pays no regard to the idea that disabled residents could be important experts in the pre-planning of their own evacuation, that responsible persons could meet and learn from them. And it shuts its eyes to available best practice on inclusive evacuation planning across the country and the world. It also raises troubling questions as to the underlying motivations. Budgetary concerns can no longer be allowed to uncritically trump a matter as important as equal enjoyment of safety in the event of fire. Ultimately, the view that nothing can be done, as well as being unevidenced and wrong, sanctions an outcome, even if that is not its aim, that treats disabled residents in high-rise buildings as if their lives don't matter. I want to finish, if I may, by reflecting that there is a link between the closed nature of discussion between government, managers and specialists at this national level and what went on with the RBKC, TMO and its contractors at Grenfell. No one was particularly interested in involving ordinary people. Quite the opposite. The results are profoundly anti-democratic and disrespectful. Grenfell residents had no part in the choice of their architect, contractor, design amendments, or access to fire risk documents, nor any chance to be informed and cooperate in the pre-design of their own evacuation. Edward Daffan's statement to this inquiry eloquently tells how this tragedy played out in 3 acts: before, during, and after the fire. Each of those acts involved a markedly negative view about the wisdom and resilience of people when they come together as groups. Before, the TMO and RBKC were desperate not to recognise collective community representation. During, the firefighters thought that mass evacuation would only cause panic and injury. After, the authorities feared that there would be uprising on Kensington Street. In fact, each part of the inquiry's evidence indicates the possibilities when ordinary people come together. They speak truth to power, prompt new ways of seeing old problems, save themselves and others as the real first responders in emergency, and create the first and most enduring forms of support and recovery. Just as culture, values, and ideas were among the key causes of the fire, a more cooperative and co-productive approach involving dialogue with and participation of residents must become a fundamental aspect of fire safety in the future. But to make a firm foundation for such progress, The inquiry needs first to clearly and unequivocally identify the root cause of this disaster in the disempowerment and unequal treatment of residents. People with less influence, money, and expertise were essentially rolled over, and the various tools of human rights, health and safety, and public protest were not sufficient to save them. Thank you, sir. Those are our submissions.
Well, thank you very much indeed, Mr. Friedman. Very powerful statement, which will give us a lot of food for thought. Thank you very much. We've got to the point in the morning at which I think we should take a short break. We're running slightly ahead of ourselves, which is always welcome. So what I'm going to say is we'll break now. We'll resume at 20 to 12, provided Mr. Mansfield, who is due to speak next, is ready at 20 to 12. If he's not, that doesn't matter. We'll take him at the time advertised, which is 11:45. But so we may resume at 20 to 12, all being well, and we'll see you then. Welcome back, everyone. I'm now going to invite Mr. Mansfield, Queen's Counsel, to address the panel on behalf of the other group of bereaved survivors and residents. Mr. Mansfield, good morning. Can I just check that you can see me and hear me well?
Very much so, sir. Yes, thank you.
Very good. Well, good morning. It's good to see you. And well, when you're ready, I think we're ready to kick off.
Yes, thank you, sir. Well, sir, and Thoria, Estefan, and Ali Akbar, your co-panelists, we are much obliged for this opportunity to open for Team 2. I've listened very carefully, as I'm sure everyone has, to what has already been said, and I will try and avoid repeating the detail of the two previous submissions to you, with which we agree. So there would be little point in duplication. In addition to that, of course, we have already submitted questions as well as a written opening. So again, no purpose would be served in repeating all of that. But what I would like to do is just to pause for a moment before using a rather different approach in the hope of illustrating, in a sense, what you've heard by way of criticism of the regulations, of the people who are supposed to implement the regulations, of attitudes and so on. Before dealing with a particular approach and perspective is to bring it to life through the eyes of the families. I'm going to avoid using the term BSRs, if you'll forgive me, but the families and the voices of the families. Because the first reflective moment, because this is a historic moment in this inquiry, when after so long, we return to the families themselves and what they have to say. And what one has to bear in mind, I would ask everyone to bear in mind, is, and the reason why their voices at this moment, at this junction, are so important, is firstly, you have to remember, it's easy to just override it and forget because so much else is happening as we speak, that they, and particularly one of the people I want to mention in more detail, Shah Ahmed, had suffered a great deal before this fire. They had suffered, and somebody's already mentioned it this morning, 20 years of neglect. And the neglect isn't just concerned with fire safety. And if I may, I just want to illustrate it. It's in one sense, it's minor, but it really tells you everything about what's been going on there. It's not fire related. It didn't cause the fire. It didn't cause the death, but it tells you everything in one short cameo of what had been going on for years before this fire. A gentleman whose name I will not mention, who lived on floor 15, so one of the upper floors. He suffered from bowel cancer, and that was known. For 6 months, he had a flat in which there was no functioning lavatory. Think about that for this person. What did this gentleman have to do to get something done? And I think Stephanie Barwise said staggering lack of concern. It's worse than that. He, that is this individual, had to go to North Kensington Law Centre in order to get legal help and also get his physician to intervene in order to have a working lavatory. And then we wonder why the tower suffered in the way that he did, because that's the suffering. That's the kind of suffering. It indicates an attitude of mind that happened over that 20-year period. But then on top of that, these residents and families suffered the fire itself. And you've heard something of that, and I want to, in a very short while, just reflect on a small passage of that which illustrates what's happened. But they suffer the fire, and then afterwards, of course, they go through a terrible period in which there are more housing problems and difficulties for them just in daily living. And then on top of that comes the pandemic and the difficulties of the hearings and not being able to attend. And of course, modules 1 and 2 did not include the voices of the families, although they have plenty to say about the issues in modules 1 and 2. Instead, they had to sit at home usually and watch, and I hope this is not an understatement or even an overstatement. They had to watch a parade of arrogance. There may be one pandemic outside the hearing, there's another one inside it, and it's the pandemic of lies, of manipulation, of deceit, of jocularity, of pride in what they're joking about. And one has to ask, obviously, how that has come about. And we are approaching a different stage. It's one thing to work out how the fire was caused and how the deaths were caused. The bigger question is, why did this happen? And so therefore, the one way of encapsulating what has happened over these 20 years, and it's epitomized in the construction industry and the race to the bottom of the description you've heard before, is what we now have. And I'm going to characterize it, if I may, in this way. That what the Council, the Royal Borough of Kensington, created was a chronic culture of neglect, of that there can be little doubt, of indifference and discrimination, underpinned by, as you've already heard, a theme of dishonesty in the sense of not revealing information. How is it that the construction industry, in a sense, and the authorities you're about to hear are conjoined in one continuum? There's this bigger question of what is lying behind the construction industry's approach and the local authorities' approach. And before moving into some of the illustrative examples, there is another reflection which may have struck you this morning, if not before, probably before, well before. And that is this: the staggering lack of concern leads one to believe and leads one to examine what we've put in our written submissions, that whatever happens in this inquiry, it is important that any recommendations and it's important that any themes that come out are enacted and implemented. But as you have seen, if those in a position of authority, whether it's in the construction industry or the local authority, are of a particular mindset, it doesn't matter what the regulations are. It doesn't matter what the statutory duties are, because at the end of the day, they think they're immune. They think they can laugh about it. They think, as they did in the construction industry, well, that's what we do, lie. Is that the society that has been created over the last 10, 20 years? And we say there's a risk of that continuing unless there's a real attempt to change the mindset so that whatever one says ought to happen, and even if you set it in law, you ensure that it is enforced and people are made accountable. So those are the reflections before I even begin the examination, because what I would like to do is to go back to the night in question, just for a moment. And I want to, as it were, bring to life all those deficiencies and defaults you've heard about in the written submissions as well as the spoken today. And you were there for the pen portraits, and you've been to the tower. May I don't ask for answers, it's not a rhetorical question, that your co-panelists, if they haven't watched the pen portraits, would they be kind enough to do so, because it brings to life the lives of those who died and the eclectic quality of the lives that died, the diversity already mentioned of those who died in this remarkable, I've called it the vertical village, which has been destroyed, although the people who live on still have it in their hearts. But the pen portraits are one thing. And again, to your co-panelists, Thoria, Estefan and Ali Akbar, if you haven't been to the tower, may I ask that you do visit the tower, provided it's safe. Obviously, I'm not sure what the present situation is, and you may have already visited it. It's important in order to understand just how serious the, not just the happening on the night, but what went before it as well. And then it's put in a context. Once you've walked up that stairwell, you've walked up the staircase, you've seen the conditions, and just the space conditions, it then takes on a new dimension. So I'm going to, if I may, just read a portion. It's only a small portion, and I'll make it clear at the end. If it doesn't become clear straight away about whom I'm speaking in relation to this, and it will bear upon what we say are the important findings in this particular module. On the Tuesday evening before the fire, so that's the 13th of June, it was a normal night for me. We went to bed around 11:30, but I couldn't really sleep. I must have fallen asleep, but it wasn't a very deep sleep. I think our bedroom door was slightly open that night because it was hot. My kitchen window was open too. I'm going to miss certain sections which don't bear upon the immediate points I want to make. I got up. I didn't see any smoke until I went into the kitchen. As soon as I got into the kitchen and looked down out of the window, I saw a big fireball coming up from the outside of the building. It was the color of burning sunset. I initially thought it must have been a fire in the flat below. The kitchen window then exploded inwards. I was lucky I wasn't close to the window. I dialed 999 on the house phone from the living room. However, before completing the call and speaking to anybody, I threw the handset down and decided to get out. Until recently, I believed I'd not been completed the call. However, the police have informed me that I did in fact complete the call, although I didn't speak to anyone before I threw the handset down. And this is important for this section. I'm glad I didn't speak to the operator, as I might have been told to stay put. Well, that's a point I want to come back to. In fact, what he didn't realize was that what he then did was overheard by the operator. My wife and I banged on the door of flat 155 and shouted, "Fire, fire, fire." I then went to 154. The man there opened the door a little bit. I told him to get out because there was a fire. Then I banged on 153. But I can't remember if there was an answer. Then I banged on 152. I think someone answered, although I can't remember clearly. Then I banged on 151. A lady with a walking frame answered. I told her there was a fire to get out. There is a smoke alarm, another point you may wish to pick up on in this, in the lift lobby, but it wasn't ringing. Otherwise, the other flats would have heard it, and I wouldn't have had to tell them there was a fire. It goes on, of course, and it may be clear about who it is. He goes back to his flat to get his mobile phone. He tried to go back, but when he opened the door, he saw thick, white, black, mixed smoke, smelled smoke, something like burning. I don't know what exactly. I didn't feel the heat coming. I shut the door straight away. Then I thought, we have to get out. It was fight or flight. Through my years of fighting for the health and safety of the building, I had the instinct to know the building was not safe and that it was a ticking time bomb. Now, the person at the root of this, and his wife, Saida, is Shah Ahmed. Now, I'm going to use his, if one likes, the prism of what happened to him in order to illustrate just how serious this chronic culture fostered by the local council had been. Because he knew what he was in for if he stayed put. Not only did he know, he had very clearly signposted what was wrong with the block. So in a sense, he's an expert, and the families are experts in terms of what they knew. We have it in the building sector, the construction sector, whereby companies knew full well, some of them, that they were providing combustible materials, but they went ahead. Why? Profit. And in this area, we have a very similar situation. And the similar situation here is where they are being told, that is the authority, what is wrong and what is going to happen, but they do nothing. That is why we say it's a chronic culture all the way through, whether it's a lavatory or anything else. This is where essentially there's discrimination of a class of people. And I'll come back to that as well. Just pausing again on that particular chronicle, if I may put it that way, so that it can be seen in another context. He, that is Shah Ahmed, lived in flat 156, which is why I've mentioned all the other flats he went to, on the 18th floor. Between, and this is in your phase 1 report, between 1:20, so we're dealing with a situation obviously in the middle of the night, and 1:30, that's 10 minutes. The fire had enveloped, and anyone, I'm not asking for scenes to be shown, and that's why it's so important to keep going back to what happened here. The fire enveloped all the 6s, by which I mean all the flats ending in 6, who are on one above another in the tower, between floors 10 and 23. And in fact, his telephone call to the operator was at 1:27:56, and he exited with his wife at 1:31. So he got out just in time, but without, again, going through it, it would take too long, and it would take the number of days it did at the start and in phase 1. You then have the picture of what happened to everybody else. Some survived and a large number didn't. But what were they facing? The ones who were not able to get out in the way that he did. They were facing, as you will recall, a situation in which the stairwell was filled with increasing amount of black, acrid smoke, with the difficulty of walking down the stairs in the night, badly lit, badly signed. In fact, refurbishment, what have they done? Nothing, absolutely nothing to the means of escape. It was still in the same condition. And this again tells you how bad the neglect had been. And there are those who are making phone calls, who are being told to stay put, and others, the operator says, well, just open the door, you just got to go, you've got to go, and they're talked down. Others can't do it. Others are left to die. That's the chronic situation that has been created on the night. And those doors that he tapped on, two of them are significant because they tie in with what we say is a dereliction of duty here, now well before you. In flat 154, where the door opened, there was in fact just one man living. He died. He had a mobility problem that was known. He was disabled. He didn't die in his flat, he managed to go up. And you will recall a number did do that in the hope that there might be a rescue from above. So he, unfortunately, mainly because, of course, no one had thought about how's he going to get out then? Too much trouble to think about that? One has to just pause for a minute. What are we saying? It's necessary to have protocols and regulations before you begin to think about who's living in the block you own? Is that what is spent? Well, if that's what it takes, that's what it takes. But the problem here is whether the caring society has, as it were, left certain people at the door, including the authorities. But he died. In fact, 6 occupants on this floor died. 5 of them, he's one of them, went to floor 23 above. Flat 151, where he tapped, and 2 sisters they were, I'm not going to name them all the time. One with the frame. Those 2 sisters, they went up as well to floor 23, and they died. And just reflecting here on the total situation for a moment, out of the 120 flats, how many flats contained people who were disabled in various definitions dealing with age, either old or young, or mental difficulties, physical difficulties, reading difficulties, hearing difficulties, seeing difficulties? 52 out of the 120 flats. And I won't, obviously, either on screen or off at the moment, deal with. There's a schedule that you have. We, I think, submitted it with our written opening, which indicates the number of individuals who had an impairment. This, you would think, is common sense. You would want, as a caring authority, to ensure that you look after and provide safety. Why do we have to write it out? Well, apparently we do. But there is, and it hasn't been mentioned extensively, but I just want to mention it's in our written submission, so I don't develop it. There's an obligation upon the inquiry itself under Article 2 and Article 14 in relation in relation to human rights, the protection of life and the prevention of discrimination, and that you make inquiries and you investigate the extent to which, besides the protected characteristics here, whether there is a racial characteristic which enters this arena, because you have to ask why for so long a whole diverse community have been ignored, basically. That is a question that has to be asked. They have a duty, again, under the statutory duty, 2010, the Equality Act, a public sector equality duty. And that must not be shirked. It can't be delegated. It's not negotiable. And we say they must have known about that, but were not. 2010, it's an interesting year, happens to coincide with some occurrences I'm going to come to in a moment, 2010. So that's a very important, one of many statutes. We've put them all in our written submissions, but that perhaps rises to the surface. So that, and we give other examples of the disabled who died because there was no provision. And I'm citing, to move on in one moment, to the experiences of Shah Ahmed. But before I do, it was part of his experience as well. I'm going to go back from the night itself. In other words, we're moving back from the 14th through the 13th. There is an irony here that you might have reflected upon at some point. On the 10th of June, it's only 4 days before, there were a series of visits. Home fire safety visits. 4 firemen from the North Kensington White Watch visited a number of flats. Not all of them, but a number. And 25 altogether they visited. Now, the object usually of a home fire safety visit, 2 prime ones, well, it's obviously make sure the alarms are working, and also if there are people who have particular vulnerabilities of the kind I've already described, they should be getting advice. Now, of the 25 flats visited, 15 of those flats gave rise to 32 people dying on the night, and 20 of those 32 were vulnerable in the various categories. And one of the flats that they did go to, interestingly, they didn't go to the 2 I've mentioned next to Shah Ahmed. That's 154 and 151. They didn't go there, but they did go to his. And what's important about the visit to him, and you may remember that there was a witness in phase 1 who remembered Shah Ahmed. And it's interesting because Shah Ahmed's name is not well known, in fact. And I want to come to him in a moment as an individual representing essentially so many people in the block. But the point he wanted to make, a point he was utterly correct in making, but the fire officer who spoke to him said, "I'm not an expert. I can't help you about that. You persist with your inquiries with the council." Well, that advice was certainly right, because what he was talking about were the pipes, the gas pipes that had been inserted without consultation up the only means of escape, a protected means of escape, and then inserted into flats. And if one morning you suddenly saw this kind of work happening where you lived, I think you would be worried. Highly dangerous, inflammable gas inserted in this way. Of course, where should it have been? Outside. Couldn't be outside. They were more concerned with flammable cladding, of course, so they couldn't put it outside. However, I want to return to that, but that's just in passing. And also, before we get to a next major event I want to mention to you, going back in time, it's only a few days just before the 10th. Vents. Vents is a key element of what happened on the night and why it happened on the night as well. Vents not working. Between the 6th and the 8th of June, there's plenty of documentation to indicate it was known that the automatic opening vents were not operating. A few days before the fire. One of the reasons hadn't been serviced. The service record for that indicates that they should be every 6 months, but it hadn't happened. And of course, they hadn't been tested. And of course, the whole of the system hadn't been tested or as an integral whole, properly assessed. So one has here, therefore, the fire visits, knowledge that the vents are not working, but then we get to what I call a key moment. Now, I'm mentioning Ahmed himself, but he would want it known that what he says, he said on behalf of residents as a whole. And I'm doing this in particular with particular emphasis because, as you will be aware, he's taken an extraordinarily responsible approach to the block, to the authority, because he is concerned and cares about the environment in which he lives. It's not just about fire, it is also about general health, welfare, and the environment as a whole. And when he made submissions, they were always detailed, they were always reasoned, and admittedly, he put them in more than once because, of course, he wasn't actually being listened to anyway, until it got to the end. The only reason things happened to move just before the fire, as we now know, as Barbara Lane has vindicated him, is because he was making a fuss. He never gave up, he persisted. It's taken its toll, which is why we say this detail. It's taken its toll. He's now no longer able to give live evidence. That's what he wanted to do. He wanted to bring it to life himself, but he can't do that. But he has, as you know, contributed 3 statements, 1 in phase 1, 2 in phase 2, 1 very, very recently in answer to a large number of extremely pertinent questions that were posed to him. And he's produced a dossier, if I can call it that, running to several volumes, in my case, printed off to 4 volumes of documentation he's assembled to assist the inquiry. So it's not only his assiduous approach and responsible approach, he's probably one of the few who've experienced it almost from the beginning. 25 years he's been there with his wife. His son was born there. And he established the Association of Leaseholders in 2010, that very year. And I will have to return to that in a moment. But what happened just before the date I'd got to, the date being the revelation about the fence on the 6th and 8th of June, probably discovered before that. At the end of May, he did something, well, not remarkable in one sense, but it just demonstrates how far, as you've already heard in the previous 2 openings, how far the neglect, in a sense, the dismissive nature has got. That what he does at the end of May, so it's 2 weeks to go before the fire, he puts together a bundle of, it's all there for you to see, a bundle of documents indicating his worries. As before, because there have been surges and other things he's had to complain about, he doesn't go on his own. He doesn't only do the leaseholders, of which there are 15 flats, and 3 are housing associations. He's not just doing it for them. He knocks on every door that he can within the block, and he achieves over 90%. Each time he does it, over 90% of the occupants support what he's doing and know him well and respect him well for what he's doing. The voice of the people unheard, unheeded, heard maybe, but certainly unheeded. So he puts together a dossier. It isn't just about the fire, the possibility of fire safety. Of course, he's got that point. He has other concerns which relate back to issues I've already mentioned. So that go over the years, the power surges that happened in 2013, and of course the fire that did happen in 2010, the year he formed the association. So he takes the dossier in person. He doesn't trust sending it because he's tried all that. You will see on his emails, he copies in pretty well everybody you can think of. So Judith Blakeman, the local councillor, essentially lives nearby, has a surgery nearby, knows well what's going on. So that's a familiar name and will become more familiar. But he doesn't restrict it to her. He goes to the MP, he goes to ministers. And what he's been forced to do at this late stage, because he believes they're not doing anything, all he was wanting, when I say all, he wanted reassurance from the council that they were getting on with the job, because he knew from reports he got in relation to the 2010 fire, they weren't telling the truth. In 2010, I'll come to in 1 second, there was a fire which he was unfortunately not himself present, but his wife was. But he knew that they eventually conceded on that fire that in fact he had suffered. but it took a legal action then to get them to recognise. So he felt from the fire brigade report, which clearly indicated then vents were a problem, he wouldn't trust what the council were palming him off with. So that he had decided to take legal action and go to the Housing Ombudsman at the end of May. He was preparing essentially a brief. He'd employed lawyers to go and do this. And of course, Laura Johnson sitting in the background saying, oh, well, if that's, let them do whatever they want kind of thing. Essentially, we're not going to do it. Well, they started to do something. But in fact, it wasn't without this prompting that we say the boxing in started. Now, it's a simple point. If you put pipes through a communal stairway, as I've already indicated, and into flats, there are all sorts of risks. If you're going to box it in, you've got to ventilate it properly. You're breaking the seal of compartmentation, possibly breaking the seal. You've got a highly inflammable situation should a fire break out on the stairs or anywhere else for that matter. And you will recall that it took 18 hours to find where to switch it all off. And when they did, what did they say? Fire went out like a light. Well, it had probably mainly gone out by then anyway. But in any event, this is why this was so important. And he was quite right. Even though it may not have caused this fire, even though it may not itself have contributed to the smoke and the deaths, nevertheless, as he's now supported by the expert opinions of Barbara Lane, then he undoubtedly can rest that he has done a very fine job in what he did. And this was because, in addition, would the council meet him to deal with this and Defan and others? Because he wasn't alone, he was doing it with others. No, wouldn't meet. Wouldn't give him what he wanted was the assurance of a fire safety certificate to show that what the National Grid were doing was all right. As the fireman who come to his flat said, well, continue pressing. Well, he did continue pressing. Nothing was forthcoming to indicate what assessments they'd had. So he had no idea what they were doing. So he had to do it almost in a vacuum. But, and the ultimate test in a sense was he asked the council, well, how about he said this from the beginning, how about an independent investigation? How about an independent assessor, somebody who's qualified to do the job? He asked for funding by the council for somebody independent, not somebody commissioned by the council, not somebody paid for by the council, somebody that was instructed externally. They wouldn't countenance it, they wouldn't allow him any funding, so he decided in the end at this late stage he'd have to fund it himself or try and get others within the block to help fund. So these legitimate concerns that took him to the town hall and other places on the 30th to ensure everybody had a bundle of fire risk and the rest sitting on their desk in the hope that it might make a difference. And that, in a sense, brings me conveniently to what is possibly, and I hope, again, not overrating it too much, one of the most compelling documents in the case as a whole. I've asked for this one to be put up because I think otherwise, because Mr. Shah is not going to be able to give evidence himself, his evidence no doubt will be read at some stage, certain items can get submerged and perhaps forgotten, or they don't assume the importance that they deserve. But this, and I have given the references, which I will give now, it is a letter that he wrote in 2010 to the newly appointed chief executive, Mr. Robert Black. Now, I'll give the reference, it's TMO 1003 7439 _ 001. So if that first page could come up, please. And if it could be enlarged, it might be possible for me to read it off the screen, but I've got the hard copy. The first page, it's from the Grenfell Tower Leaseholder Association. We've been set up earlier in the year. It was earlier in the year of 2010 that he suffered the fire. It's that same year that I've already mentioned in another context. But it is a year that ensuring that he wrote to everybody who really mattered or should have mattered. And there they are listed. So this isn't something where he keeps it to himself or he only does it in a particular, and he's having to do all this as he did on the 30th of May because the complaints system was outdated, cumbersome, not simple, and was used to shut them off. That's the phrase, lock them out, essentially. We can reduce this class to non-existence by having a complaints procedure, which is why he used the members request route via Judith Blakeman, who sometimes managed to achieve a little more. Now, the letter itself, I'm only going to read certain passages, not the whole. The letter is extensive and goes over, I think it's 8 pages. Yes, 8 pages. So it has signatures other than his own because he got support. And this is what he writes. We received a written response dated the 20th of August, 2010 from Mr. Daniel Wood, the head of the home ownership. However, we were expecting a direct response either from you or Mr. Anthony Parks. We've chosen to respond to you directly instead of Mr. Wood for the simple fact you originally made the commitment to look into our issues and concerns. Mr. Wood, in effect, refuted and flatly ignored our long-suffering and serious issues. This demonstrates, as head of home ownership, he's not aware of the reality of the situation at Grenfell Tower and is out of touch as to what's going on. It seems he has based his response on what appears to be common answers. If we simply take the issue of block aesthetics, it's clear to see how Grenfell Tower has been neglected for decades. The letter we received indicates that the TMO does not adhere to the promise of being tenant-led organisation. May we pause? The TMO was never tenant-led and in fact was quite the reverse. If we could just turn over the page very quickly to 0002 at the top. Second point he wants to make, we will argue that the recent fire at Grenfell Tower has raised so many health and safety issues with the building that it demands an independent investigation and inquiry into the safety of the building. Well, that's echoed all down the years. He constantly asking and is constantly refused. Now, on that page, he goes on to other issues and on succeeding pages, including, I'm not going to read it all, obviously, the lifts come into it, maintenance of the lift, garden maintenance. Can we please turn to a very important section headed Fire Alarm, Health and Safety. We are very shocked to learn at the bottom of 005, if you've got that page, yes, at the very bottom. Perhaps it could be enlarged for those who want to follow it. We are very shocked to learn from you that you consider the defects in the building exposed by the fire as a minor fault when it had potentially fatal consequences. The minor fault caused so much damage to individuals living in the Grenfell Tower, it's difficult to imagine how serious an event has to be for you to consider it a major fault. If the fire alarm system isn't functioning and the vents are not working, I pause. We compare that 2017, what's changed? Very little. Should be considered no doubt as a major fault. They're used as measures to save life. They're not working, then obviously you're endangering the lives of residents in the building. What's more, we're certain that out of 120 families living in the block, no one is aware of the evacuation procedure. Why? Because of course there isn't one. We have never had evacuation procedure booklet sent to us for the past 36 years. Is it not necessary by law to test fire alarms and associated equipment on a regular basis to check whether the system is fully functional? Then there's a paragraph about people not hearing fire alarms, that nothing's changed on that front, and smoke and suffocation. He lights upon, in the middle of that next paragraph, devastating consequences. As you know, fire does not kill as much as the effects of smoke. And of course, that's this case. That is 2017. Majority of people were suffocated by the acrid smoke that went around. And to our knowledge, some of the residents in relation to 2010 nearly died due to smoke inhalation and suffocation. Many residents found the whole experience traumatic and mentally damaging. Then there comes the paragraph just below, the staircases. The staircases of the surrounding high-rise buildings are exposed to open air and natural light, and so in case of fire, the smoke can easily escape. But Grenfell Tower, with its interior case and malfunctioning ventilation system, there is certainly a high probability that in the event of another fire, the whole building can become an inferno. Furthermore, should a fire occur in the staircase, there will be no escape route for the residents, and rightly so, because of the lift and so on. And I end this with the last sentence right at the bottom here before proposed school. So scroll down a bit to the heading proposed school, just above that. The residents of Grenfell Tower have been treated as subhuman, and your handling of the incident has been unacceptable. That letter has everything in it. That letter is warning. 7 years before, the same chief executive officer, the same TMO, that there will be an inferno. It is exactly what was said in the Defan blog, which you heard in phase 1. And I appreciate the time, and I'm going to, as it were, concertina my final remarks into a few seconds rather than minutes. The question is, why has this been allowed to happen? And I'm going to encapsulate it in very short form. It's been allowed to happen because of a climate, a political climate. And the political climate in 2010 and 2013 was one in which, and we use the analogy with the Florentine 15th century burning bonfires, bonfire of the vanities. Yes, well, what David Cameron actually said was to get rid of the safety culture. Why? It gets in the way of profit. Those were the words that he was using, and one can't balk at this at all, because if you're going to change a culture, you've got to look at where the culture is coming from. But he wasn't standing alone, and I opened phase 1 with that comment about a meeting on the very day of the fire about deregulation. That's what it was all about then. And one has to remember that all these events were happening. And of course, who was the Mayor of London at the time? The now present Prime Minister. What was he doing in 2013, just as all this was taking off? Austerity cuts to fire brigade, fire engines, work and jobs, and even the training facilities, of which there still isn't in London, a training facility allowing for high rise. And when he was taxed about this by Andrew Dismore in 2013, again, it's all part of an attitude of mind. Boris Johnson's response, get stuffed. Now we were living, and hopefully we might come out of that, get stuffed, when it comes to safety. And of course, you link it to something else that Boris has recently said as a motivating force. He may regret he said it. He may want to retract it. We'll see. Greed. Greed as a motivating force, not in relation to this issue, another issue altogether. So we say, until you roll back the avarice, until you roll back the culture of neglect, the culture of discrimination that has gone on here, then there will be no real change and no real hope for those who've had so much faith in this inquiry, including Shah Ahmed. Thank you. And sorry, I think I've run over by a bit.
Well, only a fraction, if you have at all, Mr. Mansfield. So thank you very much for your opening statement. Well, I'm now going to invite Mr. Williams from Queen's Counsel to make a supplementary opening statement on behalf of the same call participants. So just check that you can see me and hear me, Mr. Williamson.
I can, sir.
Good, thank you very much. Now, can I just mention this, that on the programme that I've got, you are done to have half an hour before lunch at 1 o'clock and quarter of an hour at 2 o'clock. I don't know quite how your statement's going to work out. Perhaps you don't either, I don't know. But if at 1 o'clock you think that you could finish within a reasonable time, by which I mean, let's say 10 minutes or so, I think we'd all be perfectly happy to let you do that. On the other hand, that's not to put pressure on you. If you'd rather break at 1 o'clock or at a convenient point around then and come back and finish after lunch, that's equally acceptable.
Yes, thank you, sir. I've got I've got a carefully worked out timing, and I'll take a view as to where we are when we get to.
Well, exactly. Take
get to that stage. Thank you very much. But Mr. Chairman, Ms. Estevan, Mr. Akbor, I shall deal first with topic 2. And the core issue for this topic is for the inquiry to ask itself how the tower, itself home to many vulnerable residents, came to be a building that was so defenceless when it came to the risk of fire. It was, of course, unprotected in the face of what we now know was a massive risk, namely a situation in which, as the Phase 1 report made clear, the external walls of the building actively promoted the spread of fire. Standing back from the detail, there is a stark and simple question. If the tower had been the subject of adequate fire risk assessment in the years leading up to 2017, how was it that 72 people died in a catastrophic fire? This was a fire safety failure on a monumental scale. At the heart of this failure was the TMO. Its personnel lacked the relevant skills to provide a safety strategy to protect the tower against fire, and they took no adequate steps to ensure that other suitably skilled persons were engaged to carry out fire safety work. There was, in fact, at all relevant times, no fire safety strategy in place. Without such a strategy, the basis of an integrated approach could not exist. Exover failed to provide a strategy, a failing which was not recognised by them, the TMO, RBKC or Ryden. Indeed, from at least 2010 onwards, Grenfell's fire safety was in a perilous state. The TMO then reached an agreement with the fire brigade that any remedial works identified in fire risk assessments would be made fully compliant within 5 years. This was an extraordinarily lax and leisurely timetable, showing how complacent at best the TMO were about fire safety. This approach was entirely contrary to the interests of the residents and demonstrated also a reluctance on the part of the LFB to utilise their enforcement powers. In fact, as Dr. Lane states in her report, over the next 5 years, the risk level rose from medium to intolerable, meaning that the premises should not have been occupied at all until the risk was reduced. Over these years, the TMO essentially entrusted all fire risk matters to Carl Stokes as the fire risk assessor. He was not a chartered fire engineer, and he lacked the necessary skills to carry out the work. As regards his qualifications, we emphatically do not agree with the view expressed by Mr. Todd, one of the inquiry's experts, that, quotes, little if any special competence is required in relation to the principles of fire safety to enable a competent fire risk assessor to carry out a Type 1 FRA for a high-rise block of flats such as Grenfell Tower. Indeed, I should make it clear at this stage that we do not agree with Mr. Todd's general approach and do not accept that he is an appropriate expert to guide the inquiry. We echo the criticisms made in relation to his evidence this morning by Ms. Barwise and Mr. Friedman. In relation to all relevant matters, the inquiry should therefore take its cue from Dr. Barbara Lane. In any event, the TMO's faith in Stokes was not universally held by others. In a meeting between the TMO and the LFB in January 2016, Rebecca Burton of the Fire Brigade, quotes, raised her concern that our fire risk assessor sometimes makes statements which are not justified or supported, and that the FRA reports need to include justification for statements made. The TMO, however, relied on Stokes to give advice on the refurbishment works that would have been more appropriate if he had been a consulting engineer rather than unregulated fire assessor with no formal engineering qualifications. As Dr. Lane puts it, the TMO appears to have instructed Mr. Stokes, quotes, to undertake ad hoc inspections of the works. Mr. Stokes recorded these inspections in letters to KCTMO. I've seen no evidence, says Dr. Lane, as to how Ms. Ray or the TMO addressed issues raised by Mr. Stokes in these letters, which do not appear to have been part of any of KCTMO's formal processes or procedures. Crucially, and compounding this error, the TMO excluded the building's facade from Stokes's scope of work. He did not take exception to this, despite the fact that his brief asked him to consider the compartmentation of the building and any possible shortcomings with it. Compartmentation simply cannot be considered when a wall is excluded from scope. On any view, the exclusion of the facade from the assessment was an extraordinary omission. Clearly, the facade was of critical importance and urgency. In August 2016, a fire had occurred on the 18th floor of Shepherd's Court, an 18-storey tower block in Shepherd's Bush. Cladding on the outside of that building comprised polystyrene and plywood insulation panels. Tests concluded they were the likely cause of the fire spreading up the outside. The similarities to Grenfell were striking. Flames began pouring from the open window of the 7th floor kitchen, quickly spreading up the side of the building. At the time, the publication Inside Housing described the fire as a stark warning for social landlords. 8 months later, in April 2017, the LFB wrote to Laura Johnson of RBKC to say that testing showed that the combustibility of the panels at Shepherd's Court did not meet the levels expected to comply with building regulations. This letter caused Ray to ask Stokes whether the cladding recently installed at Grenfell complied with building regulation requirements. He replied in an email sent from his mobile phone that, quotes, Grenfell was clad, but the cladding complied with the requirements of the building regulations. Lots of questions asked of Rydens and answers received back from them. In an internal email the next day, Ray reported that she had, quotes, checked with Carl Stokes, who had investigated the details of the installation with Ryden when the works were on site, and he confirmed that the installation complied with the current requirement of the building regulations. In fact, Ray had misrepresented Stokes's two-line email, which had not addressed the nature of the cladding at all. The last FRA completed before the fire, shortly after the completion of the refurbishment, noted that the tower appeared to have appropriate fire separation and compartmentation, and from a visual inspection of the structure, no areas appeared to raise concerns. Stokes felt it appropriate to make these unqualified comments, but he did not, firstly, assess the materials used in the construction of the cladding, secondly, complete or recommend any invasive assessment of the materials, thirdly, seek the input of a chartered fire engineer, fourthly, consider material classification or materials safety data sheets for the cladding, or fifthly, make any inquiry of the basis upon which building control had passed the cladding. Both Williams and Ray of the TMO now rely heavily on the words in Stokes's FRA assessment that the building appeared to have fire separation, appropriate fire separation and compartmentation. This reliance is clearly misplaced, given they were both aware that Stokes had not been instructed to consider the external facade of the tower. As to all this, Dr. Lane concludes, not surprisingly, that neither Mr. Stokes, nor Ms. Ray, nor her superiors in the TMO demonstrated competent understanding of the hazards posed by the works at the time, and they did not make a suitable and sufficient assessment of the risks to relevant persons. Moreover, in relation to this building, clad as it was in combustible cladding, and in respect of which Stokes had never been asked to consider the external facade, evacuation planning had never been made part of the TMO's procedures for tower residents. Indeed, in her witness statement, Ray takes a dismissive view of any requirement for evacuation plans, saying, quotes, "It was also not our role to capture where disabled and vulnerable people might be living in the tower. This type of information, where available, was kept by the neighbourhood management teams, which were part of the operations department." That approach is clearly contrary to the non-delegable, strict duty of the TMO were under to ensure, so far as reasonably practicable, that residents were safe from harm. It also ignored the relevant guidance on the topic. As the responsible person safety officer under the 2005 FSO, Ray should have ensured the TMO discharged its evacuation planning safety duties. The TMO did not engage with this at all. It did not take resident safety in the event of fire seriously. For example, Councillor Blakeman, to whom Mr. Mansfield's already referred, whose area included the tower, notes in her witness statement that following the refurbishment, quotes, "Residents received no advice about fire safety, and only after several representations were instructions as to what to do in the event of a fire installed on the walls of the communal hallways. It was left to the residents themselves to be proactive in order to obtain this advice." Indeed, the statements which have been given across the entire group of the bereaved survivors and residents suggest that the TMO's practice in relation to the provision of fire safety information was grossly deficient. Many residents reported they were not given fire safety advice or information about what to do in the event of fire. The FRAs suggest that Stokes did in fact understand that evacuation planning was essential in the event of fire. However, he appears to have thought that evacuation planning could be effected ad hoc by either the fire service or residents themselves, which is contrary to government guidance and represents a flagrant disregard for resident safety. There is no reference in any FRA of a documented emergency plan. Neither did the TMO produce any document on the subject. This was a serious breach of their legal duties to the BSRs. Furthermore, as Ms. Biowise has explained, there were no TMO drafted PEEPs, i.e. individual plans for means of escape from fire, in place in the tower for any of the residents. This was despite the existence of well-known and long-established guidance on vulnerability. Some 20 or so tower residents were vulnerable in one way or another. Stokes did not prepare any PEEPs at Grenfell. He apparently understood that Ray's team were drafting them. As with so many of those involved with the tower, he relied upon an unjustified assumption. The TMO's non-delegable duty to keep the residents safe was not in any way diluted by any resident's mental health issues or physical vulnerability. On the contrary, it placed a burden on the TMO to ensure that any such vulnerabilities were accommodated. The TMO should therefore have ensured that there were in place adequate PEEPs for disabled and vulnerable residents. It failed to do so. Furthermore, Stokes advised the TMO in 2014 that the lifts were firefighter lifts, even though this was not the case. On the night of the fire, this caused an avoidable loss of life. Others with limited mobility and mental health vulnerabilities may have lost their lives because they did not feel able to utilise the lifts to evacuate. I will return to the issue of the lifts in a moment. The evidence on topic 2 will show, therefore, the following things. 1, there was at all relevant times no fire safety strategy i.e. no overarching basis of fire safety engineering in place. 2, Stokes was not qualified academically, vocationally, or by experience to carry out the complex FRAs that Grenfell required. 3, the FRAs were wholly inadequate, in particular in that they did not deal with the facade and external envelope of the building. 4, there was no adequate evacuation plan and no emergency plan. 5, no proper consideration was given to vulnerable residents. And 6, no PEEPs were prepared. I turn now to topic 3. Topic 3 deals with a diverse range of issues concerned with the operation and maintenance of the tower. Although these issues are various, they have a unifying theme: the failure of the TMO to ensure that the tower was properly and safely operated and maintained. The TMO then carried out works, as we have seen in modules 1 and 2, which involved fixing to the tower highly flammable cladding products, turning the tower into a death trap. The building was, in view of the series of failings I am about to consider, singularly ill-equipped to respond to or withstand a catastrophic fire. Dealing first with the doors. The TMO and a company called Mance entered into contracts for flat entrance door replacements in 2011. This was an ideal opportunity to ensure that all the doors were fire safe. It was not taken. Indeed, instead, the contracts failed to specify the door's performance requirements. The TMO was well aware that it was necessary to ensure that all the doors in their estate were fire safe. Indeed, in January 2010, Ray had informed a meeting of the TMO's Health and Safety Subcommittee that, quotes, the main issues being raised were in relation to 1, inspection and, if necessary, replacement of flat entrance doors in enclosed blocks to ensure they present a sufficient level of fire resistance, are self-closing and fitted with intumescent strips and cold smoke seals. And as another point, where flat entrance doors are demised to lessees, can they be persuaded to replace them with appropriate fire-rated doors? Can we enforce this in respect of leaseholders? If not, it is the fire assessor's view that we would need to adopt an evacuation strategy within our blocks and not defend in place. And this has significant implications for the installation of automatic detection, etc. In the event the leaseholders' doors were not subsequently replaced and neither was an evacuation plan put in place, it is likely that many of the leaseholders would not have been able to afford new doors. Given the relatively low number of leaseholders, the TMO should surely have included them in the replacement programme. No doubt they did not do so because of concerns over costs. By February 2013, by which time the door replacement programme for the tenants was substantially complete, the TMO reported to the GTLA, the Grenfell Tower Leaseholders Association, that, quotes, we've recently had a fire risk assessment for Grenfell Tower reviewed, and the assessor advises that none of the properties at Grenfell Tower are highlighted as having potentially non-compliant entrance doors. It seems, therefore, that the doors currently installed provide sufficient fire resistance. This was dangerously complacent advice. It also ignored or forgot the concerns expressed in 2010. Furthermore, various non-compliances were noted in Stokes's June 2016 significant findings and action plan, including non-compliant entrance doors and newly fitted doors which did not have cold smoke seals. Some of the doors had had their intumescent strips painted overs. Some staircase doors did not fully close, and the 16th floor door was damaged. There were therefore multiple examples of fire safety breaches. Indeed, on 17th November 2016, the London Fire and Emergency Planning Authority sent a notification of fire safety deficiencies in respect of Grenfell Tower to Ray in her capacity as the Health and Safety Manager of RBKC. This set out numerous alleged breaches of the FSO. These failures highlight a systemic failure on the TMO's part to take action. Indeed, this was not just at Grenfell, but also in other blocks. In December 2016, a TMO Safety Board update was issued following deficiency notices issued against 4 TMO properties, including the tower. This referred to several notices queried with the LFB and expressed surprise at having received the notices. On 16th March 2017, just 3 months before the fire, the TMO's Health and Safety Committee met to review the fire strategy and provide an update on self-closers. The minutes record, and could we have a CST 6065 at page 5.
Mr. Williamson, we have it on our screens.
We do, but that's actually that's not the right document. If we could get rid of that, and I'll just move on because time is short. I was referring to the minutes of March 2017, which in summary recorded that there had been a discussion with RBKC in March of 2017 in relation to the issue of self-closing devices, and it had been agreed that there was no need to deal with them, and if the LFB were to make that a priority, then the TMO, quotes, would take legal advice and make representations to the GLA in advance of instigating any inspection programme. What is so striking is that the TMO were determined to do nothing if they could possibly do so, and to spend money if they had to on lawyers rather than on improving fire safety. LFB's senior fire safety officer, Mr. Finn, subsequently visited the tower and produced a report. This is dated 18th June 2017, but was clearly prepared before the fire. He noted that a significant number of the self-closing devices on the composite fire doors to dwellings above the 3rd floor had either had the self-closing device removed, or this device was broken and still in place, but ineffective. It is unclear what action was taken by the TMO to rectify the many outstanding fire door failures prior to the fire. However, in view of the history of non-compliance, it is likely that either no action or insufficient action was taken. On a related issue, in April 2018, the Government Legal Department, on behalf of the MHCLG, wrote to this inquiry setting out the results they had obtained, having tested Manx doors in various London boroughs to ascertain their fire resistance. Of 14 doors tested, only 1 survived longer than 30 minutes. The only compliant door was manufactured in 2009, indicating that Manx's manufacturing after 2009 had a direct effect on door quality. Manx's technical manager, Mr. Duncan, is noted by other witnesses to have instructed changes to manufacturing that affected the door's integrity. And the company's production team leader, Mr. Whitten, confirms in his witness statement that the impetus behind the drop in manufacturing standards was to save money. The experience of those we represent underlines all these failures. They speak of replacement doors where door closers broke shortly after being installed and were never fixed, and the doors never functioned properly. They speak of lobby fire doors that would not close. In short, there was a long and sorry history of defective and inadequate fire doors at Grenfell Tower. The TMO never addressed this satisfactorily or at all. The LFB attempted to do so, but ineffectually. The door's poor quality had a significant impact on the spread of smoke and flames throughout the building. Returning then to the lifts. The lifts at Grenfell Tower should have been fire-fighting lifts, but they were not. In 2004, Apex Lifts were appointed by Butler Young lift consultants to refurbish all 3 tower lifts to the latter's specification. However, this refurbishment did not specify firefighting lifts, even though the concept of a firefighting lift had been in force for some years prior to this first lift project. The TMO, Butler Young and Apex do not seem to have considered compliance with the objectives of firefighting lift requirements. All of them should have been keenly aware of the requirement for the lifts at Grenfell to have such a capability. The failure to upgrade the lifts in 2004 and the lack of consideration in the intervening years was a grievous safety breach, the ramifications of which had grave consequences in 2017. What is particularly poignant is that this upgrade could have been achieved for a cost of about £20,000 or 3% of the total contract price. 3% is a small price to pay, particularly given the importance of these firefighting lift features. The inquiry's lift expert, Mr. Hawkins, has observed that he would have expected a reasonably competent lift consultant to have considered modernising the lifts to the firefighting standard, and we agree. There was then a further lift project in 2014-2015. This too did not address the issue of an upgrade to modernise the lifts to the firefighting standard. It should have done so. In May 2015, the TMO produced an internal document called the KCTMO Fire Safety Policy and Strategy. Section 18 of that document dealt very briefly with fire safety and lifts. However, it did not reference a single standard. Having regard to the standards that should have been considered, the combined effect which give definition to the concept of a firefighting lift, the TMO document is clearly inadequate. The TMO undertook no reasonable review when compiling it. Many essential features were omitted. Furthermore, the lifts were not adequately inspected or maintained. The report prepared by WSP on the lifts in 2018 after the fire confirmed that the tower's lifts were not interfaced with the lobby smoke detection systems. The level 2 fireman's switch was disconnected and the ground floor switch inoperable. It is clear from the witness evidence that the TMO did not test the fire control switches weekly as required under the British standard. Had they been tested, the TMO would have identified that the switches were inoperative and should have fixed or replaced them. This became an important issue on the night of the fire. In summary, the lifts were, at all relevant times, not firefighting or evacuation lifts, and they were, furthermore, defective and inadequate. Those with mobility issues depended on these lifts to self-evacuate. The TMO were fully aware of these shortcomings, but took no adequate steps to address the same. So I've got about another 10 to 12 minutes. So shall I continue?
Would you prefer to do that? I'm quite happy that you should, if you would.
I think it would be better to do it all in one piece, if I may.
Of course, yes.
Yeah, I'm not absolutely promising 12 minutes, but that's what I'm aiming for. Thank you.
You carry on. Thank you.
So I turn then to maintenance. From 1996 onwards, RBKC had delegated to the TMO all the relevant repair responsibilities through a management agreement contract. It is apparent that these responsibilities were not well discharged. As long ago as 2009, following a detailed investigation, Mariah Mamoli reported that there were a number of tenants, leaseholders and freeholders within the borough who felt aggrieved that their problems had not been resolved by the TMO despite several years of complaining. The concerns dealt with included repairs, service charges, and the like. The report went on to say that the TMO now needed to tackle not only the governance, but the real operational issues around the services it provided to meet the demands of the residents within the borough. And she said this: the new board needs to win the hearts and minds of these disgruntled residents who've had grievances going back several years. The board must understand its constitutional and legal role and take collective responsibility to spearhead the TMO in its improvement plan. In December 2009, Mr. Black, already referred to, reported to the TMO board that the RBKC adjudication report had now been published, and the RBKC and the TMO have an agreed strategy to manage any issues which are arising. This was a reference to another report by Mr. Butler on long-standing complaints of residents of the TMO. Despite the so-called agreed strategy, matters did not improve over the next few years. Tenants and leaseholders were in frequent communication with the TMO with a view to persuading them to carry out their obligations in respect of maintenance adequately. However, the TMO often seemed unwilling or unable to do so. This lack of attention to maintenance had disturbing consequences. For example, in 2014, RGE Services, a specialist company engaged by Max Fordham to report on the vent system, told them that they had advised of, quotes, every service to the TMO that in the event of an activation, we cannot guarantee that the system will work. In March 2014, the LFB carried out an inspection and noted a number of maintenance failures with worrying effects. For example, that no suitable system of monitoring was in evidence to identify deficiencies with the smoke ventilation system, and that about 30% of the AOV vents were in the open position, all this indicating a general failure to maintain the system. The LFB gave formal notice of these and other deficiencies regarding Grenfell Tower to the TMO on 24th March 2014. Moreover, as with so many other aspects of the refurbishment, there was a striking lack of clarity as to who was supposed to be dealing with maintenance issues during the currency of the works or thereafter. Indeed, as early as October 2016, issues relating to the maintenance of the completed system were apparent. An inspection noted that the actuators were not working correctly on the AOV system. There are multiple examples from our clients of the lifts being commonly out of use and the lift doors not closing over extended periods of time, resulting in service outages. Nonetheless, the TMO seems to have taken the view that it could handle maintenance issues entirely in-house. On a site visit with Williams on 24th October 2016, Mr. White of JSW, a company engaged in this area, recalls in his witness statement that he, quotes, mentioned to her that it was important to set up a maintenance log and use people who understood the plant and equipment. This involved regular, sometimes daily, physical checks of the equipment and the display panels to see if anything was out of the ordinary. I formed the impression that the TMO would get these checks done by their on-site caretaker rather than by their external maintenance contractor. This complacency was not justified by events. Moreover, there was a lack of clarity as to which company was obliged to carry out regular maintenance. This lack of clarity extended to the maintenance of the lifts as well. Mr. Wallace of PDERS, the company responsible for lift maintenance, who inspected the lifts in April and May 2017, has confirmed in his witness statement that he did not see a copy of any operation and maintenance manual when he began working on the lifts at Grenfell Tower. In conclusion, as to maintenance, what is noticeable, as with so many other aspects of the TMO's performance, is its inability to get to grips with maintenance problems. The tower needed a systematic plan for planned preventative maintenance and reactive maintenance put in place by the TMO. The TMO then needed to follow up assiduously to ensure that what was planned and agreed was put into practice. None of this happened. At best, various organisations responded ad hoc as problems arose. Often this response consisted in little more than the assertion that some other body needed to deal with the issue. All of this contributed to the poor state of the building on the night of 14th June 2017. Indeed, a post-fire audit report on TMO's repairs direct organisation is an indictment of just how poor the TMO's own in-house repairs and maintenance organisation was, concluding, quotes, "It is a reasonable statement that the service, 1, isn't good quality, 2, performs poorly, 3, is expensive." Dealing finally with gas, on the night of the fire, the time taken to isolate the gas supply was woefully prolonged. As Mr. Manfield mentioned, as soon as the gas was isolated, the fire went out like a light. The background is that due to a failure in the existing gas supply line, a new line had to be installed by Trio. These works were carried out in a chaotic fashion. In the early part of 2017, residents raised concerns about the newly installed exposed gas pipework in communal areas and stairwells. It seemed to take emails from the residents for either the TMO or the contractor Tenant to do anything about the gas pipeworks. The TMO were, as ever, purely reactive. As Dr. Lane observes in her recent report, it therefore appears that the residents' complaint prompted the TMO's top management into pursuing Tenant and Trio to expedite the commencement of the fire protection works to the gas replacement riser. However, KCTMO top management failed to seek assurance that the risk to relevant persons pending completion of those works was being adequately controlled. Moreover, a riser survey undertaken by Tenant at the end of September 2016 did not locate any isolation or service valves on either of the 2 gas supplies entering the tower. A subsequent hazard and operability study specified the investigation of the reported absence of those valves. It seems, however, that nothing was done about it. This was a clear breach of Regulation 13 of the Pipeline Safety Regulations of 1996, i.e. a failure to maintain the gas supply in good order. The replacement service installed in 2017 suffered a similar fate. No trace was found of a valve surface box at the expected location of the pressure isolation valve, either by Mr. Hancock's, the police, or Corgi Technical Services. This is an extremely basic safety provision. It is highly unlikely isolation valves were not installed. The failure to locate the valves on both occasions was likely to have been due to contractors building over areas where the valves were installed. The evidence shows, in fact, a complete lack of information that would have assisted Tenant or the LFB in locating the isolation valves. The effect of this litany of failures is that the tower's gas supply took much longer to isolate than should otherwise have been taken. Our clients consider this a very important point. The fact that the supply could not be isolated for many hours was as a direct result of incompetent design decisions and inadequate construction management decisions taken many months before the fire. So to conclude on topic 3, we say that the evidence shows that the TMO and its advisors never got to grip with a range of key issues. In particular, 1, the fire doors were defective and dangerous in numerous respects. And as the LFB reported at the time of the fire, they likely provided no protection. 2, due to a pre-considered decision not to plan escape routes, there was no evacuation plan. 3, none of the lifts were firefighting or evacuation lifts. 4, a litany of failures meant the tower's gas supply took much longer to isolate than it should have done. And 5, the tower was not adequately maintained. Much has gone wrong, and this will no doubt be investigated at length in the weeks to come. However, this inquiry needs to think about the future as well as the past to ensure that failings of this kind do not happen in the future. Its recommendations, should we suggest, include the following matters. First of all, the obligations on local authorities and other social landlords to consult and inform residents and residents' organisations on fire and other safety matters need to be strengthened. Secondly, those who conduct FRAs should be required to have specified appropriate qualifications and should be subject to a professional code of conduct. Thirdly, in high-rise blocks, there should be clear requirements for the fire safety of all doors, whether those of social tenants, leaseholders, or in communal areas. Fourthly, lifts in such blocks should be firefighting lifts. And with those observations, that concludes my oral opening submissions. Thank you very much, sir, and thank you very much to the panel for your listening to us.
Well, thank you very much indeed, Mr. Williamson, and you've done very well. You finished within the time that you suggested you were aiming for. Well, that's a convenient point for us to break for some lunch. We will resume at 1:15, and the next speaker, who is going to be Mr. Maxwell Scott, is expecting to start at 2:15, so that will suit everyone very well. So 2:15 then, please. Thank you very much.